Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning. Up. Get me up and going. Good morning, everybody. I hope this finds you well. We are having problems with court this morning. We were supposed to be in court this morning with the case that we've been following, which is the love affair murder trial, or Red Room trial. Hi, Sunny Day. Hey, Bama Green Eyes. How are you? And unfortunately, it appears that there's not going to be trial today. It is rumored that the prosecutor was in a car accident. I don't know to the extent of that. I don't know if that is accurate. I have no idea. But they did cancel court for today. I apologize with that, y'all. There's nothing I can do about that. So what we're going to do is we're going to go into another trial that's been going on. And some of y'all have been watching it in other channels, I'm sure. And it is going to be I got to get it up. Give me a second. It's the Pizzoni scheme trial. They are in. I want to go back because I watched a little bit of this. We're going to go back to this morning. Let me get everything lined up. It's really sad. I think she's okay. I don't know if she's okay. Howdy, Yana. How are you doing? How you doing, Bama Green Eyes? And one so sunny day. But we do have a situation with a trial that we were watching. Apparently, something's gone on. It is rumored. It was stated that the prosecution person that was in lead prosecution in this case got in a car wreck, so there will be no court today. So we're gonna watch this. This here is and I know some of y'all, like I said, have probably been keeping your eye on this. I think she already tried her case yesterday in court. I've never known a prosecution to put on an opening statement that lasted all day, literally all day. Hey, Spawn of AJ, glad to see you. This trial that we were watching was absolutely wild. It had Red Room, it had X, it had photos of unclothed bodies being sent back and forth. I mean, anything and everything you want in a case, this had it. It was crazy. So, unfortunately, though, prayers go out to the people involved in the accident, if that was case is what happened. So what we're going to do is we're going to join Natalie Cron's day 8, Ponzi. Is that how you say it? Ponzi scheme murder trial. This is the last bit day.
Last paragraph. May I remain seated so I
Certainly, yes.
Okay, so we're going to start here. This questioning is so funny. I actually was listening to this morning, or reading, captioning this morning. So we're going to watch this. I will put a change on my thumbnail. I got to do it while we're doing. Yeah, definitely prayers going up. Go watch yesterday's. Cameron, if you want to catch up, watch yesterday's. It is an all-day opening statement by the prosecution. It is wild, wild, just absolutely wild. So we're gonna zoom through all this.
We honestly don't know, Your Honor. We were provided with 100,000 files. I can't tell if we did or not, and we have not reviewed these prior to the presentation.
Let me ask Mr. Truman, did the state provide the defense with these documents?
We did. This is the download of the defendant's phone. We separated them, and we've already agreed not to submit all of the downloads of the phone messages that are not already in evidence. So it's down to this stack of a few right there. The state does have a suggestion. In order to expedite this, we can probably eliminate some of these, and that could save us some time.
Okay.
I'm gonna zoom.
Do you get what number? Are you?
1 minute.
Please.
More specifically between.
Okay, this is where I want to get. Thank you for joining us for day 8. Thank you, Yana, of the West Virginia Natalie Cochran. Is that how you say it? Cochran? Murder trial or Red Room trial. We, like I said, had another trial, but unfortunately, it appears that the DA had got in a car accident. And I just dropped my cookie on the floor. Sensei, here. Right here, Doris. I normally don't, but she's going to enjoy that. Did you get it all? You sure did. Oh my gosh, you're such a good girl.
Preliminary question.
Okay, go ahead.
You previously testified that you and Tim Bledsoe,
Dipping it in my
both
coffee.
retired troopers, were the lead investigators in the 2 cases, correct?
That's correct.
As part of your investigation, did you interview the defendant's children?
No, we did not.
Why not?
At the time of the investigation, and more specifically between March and June, March is when we began the investigation. June is when we executed a search warrant on the defendant's residence. During that period, we were collecting information from third-party records. We were collecting information from witnesses, from financial institutions. And there was nothing in that 3-month period to indicate that there would be a need to speak to the children. The second and most important thing was their age. They were very young at the time. One was 10 or 11 and one was 13. And we were looking at the business of the Cochrans. We were looking at the Cochrans individually. So there was no indication or any reason to speak to the children. And then the final reason we wouldn't speak to the children is we've been long taught in law enforcement and investigations that you don't speak to children under the age of 18. And there's some tolerance there with 16 and 17, 18-year-olds, but you don't speak to anyone that young without a parent's permission or without an attorney present. So we would not, by normal operating procedures, have spoken to the children.
You were in the courtroom when the 2 children testified on behalf of the defendant, correct?
I was.
And in their testimony, they indicated to you who actually ran the company businesses.
I did hear that testimony, yes.
And what were the children saying as to who was controlling the Cochran's businesses?
The children put a lot of responsibility or.
I'm going to object to this. The jury heard the evidence. The jury can draw whatever conclusions from the children's testimony. This witness does not need to editorialize on that.
Sustained.
You're being recalled as a witness for the purpose of rebutting the testimony provided by the children. Is that
Yes.
correct? Okay. Thank you. Hand you an abstract from what's been admitted as State's Exhibit 3. ask you to look at that as well as a second page, also an abstract of what's been admitted, State's Exhibit 3. Recognize those documents?
I do.
What are they?
These are text message communications between the defendant, Ms. Cochran, and Stephanie Hamilton.
Have those back, please. At 10:15, the defendant sends a text to Stephanie Hamilton. Can you put that in some kind of context as what's going on there?
Natalie Cochran is offering Stephanie Hamilton an opportunity to invest in a government contract dealing with medical
I'm sorry,
equipment.
The document speaks for itself. Again, we don't need any editorialization as to what these documents are,
Could
what they speak of.
the state respond to that?
Sure.
That's not,
I find it funny. And I know it's bad to find it this funny, but I do. I find it funny that Baker calls this guy Penguin with a Russian accent. I just find it funny. Sorry.
not accurate. Those are statements taken and they don't say anything about a contract. It says there are two today. Two what? I think it's fair to put that in context with the witness's investigation and what he found that meant.
And for that matter, these documents do not indicate any interlocutor of Natalie Cochran. We have no idea who this is.
Well, I think we do need some explanation from the witness, and so I'll allow it. I'll overrule the objection. You may proceed, Mr. Truman.
Thank you.
Ms. Cochran is offering an opportunity to invest in two contracts or to consult on these contracts. They deal with surgical masks and betadine swabs, medical equipment. Ms. Hamilton was in the medical field.
Okay. Here's another text, and this is also a download from the defendant's phone, correct?
Yes,
And
from Ms. Hamilton's phone.
correct. And this is April 26th of 2019.
Yes.
And the defendant responds, that means next Friday is payday.
I'm going to object to this, Your Honor. This is way out past Michael Cochran's death. This document is irrelevant.
Oh,
What is the date
he's
on this?
objecting royally.
Yes.
April 26th. And the purpose of this testimony is to show that the defendant continued to run the business as she had before.
I'll allow it. Overrule.
Thank you. Trying to next hand you an abstract from State's Exhibit 2. Could you identify that?
Yes.
What is it?
This is a text message between Natalie Cochran and Chris Davis on February the 6th, 2019.
Judge, I think we really need to approach the bench at this point.
All right.
Oh, really? Okay, they're approaching the bench, y'all. They are approaching the bench. I've watched a little bit of this. Apparently, and I may be wrong, so I need my mods or people who know more about this to let me know. But she's a pharmacist. And what I gathered from yesterday's testimony, and I could be wrong, that did she give him insulin? And she faked cancer. She kept trying to get diagnosed with cancer, but she didn't have cancer. Give me a second. I started a new med and it makes me a little nauseated. Give me a quick second. Wait a minute. It says here that Natalie Cochran, 38, received a sentence of 135 months sentence for previously pleading guilty to an agreement. What? For unusually sinister
Continue, Mr.
$2.5
Truman.
million Ponzi scheme that swindled her family and friends. So this is a two-phase trial.
February 6, 2019.
I gotta pause this.
9:20.
Natalie Cochran, 38, received a sentence after previously pleading guilty to an agreement with the prosecutors that called for a sentence between 37 and 135 months to be decided in by sentencing of a judge. She received 135 months. She is in a federal prison. Cochran and her late husband, Michael Cochran, owned and operated a technology management solutions business. In that, both of which registered as federal government contractors. So they lied about their finances. I get that. They lied about for federal fraud and other charges that But now she's on trial for unaliving her husband, and she did so, if I remember correctly or learned correctly, with medication, and she was had access to. Wasn't she working as a pharmacist, or she had access to pharmaceuticals? Now she's on trial for unaliving her husband. Wow.
27. That's a text from the defendant to whom?
Chris Davis.
We'll have these marked collectively, but if you could take a review of those documents. And if I could have this marked as States 34, please.
All right.
No, this will be State's
Well, we didn't-
Exhibit number 37.
We're not, those weren't allowed.
These aren't allowed?
No.
These right here.
Why are they not allowed?
What's the
30.
number?
34 and 35, I think. Or 35 and 30, 35 and 36.
So those are not going to be admitted?
These, well, the ones that you marked previously are not. It's this one in its stead.
What I heard yesterday about
36.
some of the way he
That's fine.
was,
Sure.
it should have been a 911 call immediately, and he was delayed.
Exhibit
Um,
37, Your Honor.
I
Thank
haven't
you.
watched every day of this, but I watched a little bit, and I'm like,
States
dang.
37.
Yes, sir.
Okay.
I don't know why I feel so hot today.
States 37, marked for identification. Tell us what that is.
These are text messages between Natalie Cochran and Wendy Poteet.
Who's Wendy Poteet?
Wendy Poteet would be the sister of Natalie Cochran.
And how
Right.
did you acquire those documents?
These documents, they're cell phone text message documents. These were recovered from Natalie Cochran's cell phone subsequent to the search warrant executed at her residence. The cell phone is given to a forensic examiner and they do an electronic download of all the data on the cell phone. And these are pages from that extract.
And that was from a search warrant?
Yes, sir.
Now, we don't necessarily have to go through all of these. Let's just put a few up here to show where this is going. Four. Oops, can't get anything out of that.
Yeah, I think she did have a hand in unaliving him. I do remember them talking about having diabetic medications in a home where there was not a diabetic. But if you have a friend who's a diabetic and they're a lot, I could see them having insulin there in case they needed it. I have family and friends that I put an EpiPen in each one of their homes.
Once
Only
again, these
3
are
homes,
text
but
messages
I'm deadly
between
allergic to citrus, so if I get a
and
cross-contamination, cat,
Yes.
And she's
I
offering.
get a
contract.
cross-contamination, I'm prepared.
Wendy Poteet was already a investor victim of the contracts, and she is,
Oh, poor
We don't
dude.
know anything about Ms. Poteet.
All right, that's a fair objection if you'll refrain from speaking of her as a victim,
yes,
please.
Your Honor.
Continue.
Wendy Poteet was an investor, and this is reference to a contract that she is owed money on. And Ms. Cochran is advising her that she's going to be paid by certified check.
Once again,
This is a text message.
Your Honor, can we please have this identified? Which document?
number 5.
Text message, again, between Natalie Cochran and Wendy Poteet, where Natalie is offering additional contracts for Wendy to invest in on February 18th of 2019.
Now, collectively, is there a pattern emerging here in terms of the defendant's conduct of the business?
To object to this question, that's argumentative.
Or we could just go through slide by slide.
Overruled. Continue.
Is there?
These contracts were dated after the date that Michael Cochran collapsed on February 6th. So this is a continuation of these illegal business operations, the investment, the Ponzi scheme that we'd spoken about. This is a continuation of those after Michael's not available.
This time for sure. Please.
This will be State's Exhibit number 38, Your Honor.
Very well.
Before I go south with these.
They sound very disorganized to me. Is it just me?
This is one. Let me give that back. Take this.
You sound very disorganized, dude.
Hand you what's been marked for identification as States 38, please.
I really don't know much about this either, so I appreciate any and all comments on this case. I know very
Recognize that?
minimum.
I do.
What is it?
Which number is it?
Oh, I'm sorry.
For the,
Yes. Yeah.
beginning?
22, 23, 10,
10.
13, 14,
Okay.
16, 19, 20, 21.
Okay, so
22,
now we're
23.
looking at 10.
Collectively at the moment, but
Okay, all right.
they're not all available, but exhibits 10 through 23 or tabs 10 through 23. What is that?
These are all text messages specifically between Natalie Cochran and Michael Cochran, ranging from August of 2018 to February 5th of 2019.
5th or 6th?
These end on the 5th, February 5th of 2019.
This is page 2 of number 11. Who's that to and from?
This text message block is Natalie Cochran's text message that she has sent to Michael Cochran.
Do those numbers mean anything to you?
These are dollar amounts that she has told Michael are owed to them and their business for contract, government contracts that they have sold or obtained, been awarded would be the correct term. She's.
I'm sorry. Are you done with that one?
You want me to finish, Mr. Truman?
Please, yes.
The date of this text was on August 27th. And with these dollar amounts, she's provided other dates in which these dollar amounts will be posting. The very first entry, 3.45 million, should post tonight at midnight. That would be on August 27th. And then there's timestamps applied to the other amounts in those texts.
13. And this one from October 25th of 18.
This is a text from Natalie Cochran to Michael Cochran where she's talking about getting off the phone with government entities and that the audit, which was presented as a reason why none of the contracts could be paid out, she is telling him at this time that the audit is complete. There's some additional administrative stuff that needs to take place, and that all monies from all those contracts that he believed were being awarded and due will be available by Monday, October 29th.
I'm
You heard
sorry,
young Mr.
Bama.
Cochran testify about a 50 caliber.
I hope you feel better,
contract,
Bama
did
Green
not?
Eyes.
I did.
She
This is
kept checking his blood sugar throughout the day. Once he got to the hospital, it was 21. Oh my gosh, y'all.
And
He wasn't diabetic, was he? Was he a
this is,
diabetic?
again, a text. You recognize the phone number as to where that text is coming from?
Yes, that's Natalie Cochran's phone number.
And is that the only 50 caliber order in your investigation that you saw, or were there others?
That is the only one. This is a reference to a text again to Michael about that 50 caliber government contract order, where she is telling Michael that they, being whatever entity the contract was fulfilled with, want to double that 50 caliber order, and it would cost them $244 million and yield a return of $378 million.
$19. This one from January 30th, 2019. Who is that one from at 334?
Again, this text is from Natalie Cochran to Michael Cochran.
David,
In this
okay,
text,
David, court was canceled today. It is to be believed, not for certain, but to believe that the head prosecutor had gotten in a car accident or some kind of an accident. It said accident from what I read. So we have nothing for today well, we don't have Monica's case today. So we are watching the end of Natalie's case. It's kind of weird and creepy, actually. So I apologize for that, but they canceled court today. I'll put that
this
on a
is
banner.
following the government shutdown, to put it in context. And she is telling Michael that they have all the money being resent tomorrow, and they should be available to them by Monday at the latest. And then the feds will begin sending money on Monday. This was dated January 30th of 2019. February 1st was the date that the investors had been told that the monies would be released post government shutdown.
There's one from the 31st.
This is, again, a text from Natalie Cochran to Michael Cochran, where she is telling him that she is on the phone with Bank of America. And this is in reference to the monies that were supposedly inbound. And that's why she's talking with Bank of America.
I'm going to object on lack of personal knowledge.
All right, that's fair. Sustained.
As part of your investigation, did you download records indicating when the defendant was using her cell phone to make phone calls?
Yes.
Hope you
Did you
stay.
compare the text messagings with the downloads to see if, in fact, she was on the bank phone with the bank?
There were instances where she claimed to be on the phone and she wasn't. And there were instances where
Judge, I'm going to object. This is a broad.
I withdraw that.
Okay.
Thank you. 21. What's DFAS?
DFAS is the Defense Finance Accounting Service. It's a federal government entity that deals with defense finance.
And 2 days before Michael collapsed, there's a reference to the organization you just mentioned. Who's Betsy?
Betsy was earlier referenced in testimony to Betsy Britland. Betsy was a character created by Natalie Cochran to be a government employee that she communicated with regarding government contracts on the regular. She would ask, or when asked about contracts, she had told Michael that her point of contact was Betsy Britland with DFAS or the U.S. Treasury.
That's not in the exhibit. The witness is testifying from some other unidentified documents. I object to that.
Overruled.
Go ahead.
So Betsy Britland, who did not exist, this is a reference to Natalie claiming to have spoken with Betsy regarding the contracts and the whereabouts of the award money that should be coming to the contracts. And this text is, again, to Michael Cochran.
22. And on 2-4 at 301, 2-4-19 at 301.
Again, this again is a text message from Natalie Cochran to Michael Cochran, assuring him that all 4 wire transfers and money deposits were en route and that they potentially could show up that day on February the 4th. And she references 4.8 regarding millions of dollars that should arrive in the morning and 23.8 million tomorrow, the next day at some time.
From your review of the text messages between the defendant and Michael Cochran, the defendant and Wendy Poteet, the defendant and the Davises, the defendant and Stephanie Hamilton, was there a pattern emerging there?
Yes, there was.
And was always deception to all of those parties, was it not?
Judge, now the prosecutor is testifying. I object.
Fair point.
Sustained.
The text messages that we've reviewed in summary fashion, did they indicate a pattern to you?
They did.
What is that pattern?
That Michael Cochran was being told the exact same information that the investors were being told. Those who were relying on money to be paid back to them, the information that was given to them is the exact information that was being given to Michael Cochran.
And that all derived from the defendant, correct?
Yes.
Could I have just a moment, please?
Sure.
This is an interesting case. The doctor was very interesting yesterday.
Michael utilizing the defendant's phone and sending messages as a guise that it was her sending them. You remember that?
Yes.
Oops, I need another marker.
Oops.
This is State's Exhibit number 39, Your Honor.
All right.
Thank you. Handing what's been marked for identification is State's 39. Ask you if you could identify that.
You want me to identify?
What?
Yes. This is a photograph of a text message from the cell phone of Matt McCormick. It's a text message stream between Matt McCormick and Michael Cochran.
What time is the text message from Michael Cochran?
There are two dates here. Do you want?
The second one.
On February 6th at 1:39 p.m., there is a text message that was sent from.
I'm going to object to this. This has nothing to do with my client's statement. This is hearsay.
We don't think so.
This is a statement between two third parties. One is dead, the other one is a third party.
Care to respond, Mr. Truman?
Yes, sir. This is a text from Michael Cochran's phone when all the evidence says Michael Cochran was totally unconscious and lying on a couch.
I'll allow it. Overruled. Go ahead.
Whoa, that's
This is a text
interesting.
message at 1:39 p.m. from
Pure
Michael Cochran's
evil.
phone to Matt McCormick's phone, in which he is telling Mr. McCormick that he would be available to see him in a few days, reference a firearms transaction.
From your investigation and from all the evidence to date, is there any possible way that Michael Cochran could have sent that text?
No, not at 1:39 p.m.
Why not?
We have a timestamped photograph taken by Natalie Cochran at approximately 12:30 of Michael Cochran laying on the floor at their residence. And then soon after, we have witness testimony of individuals at their house with him in his unresponsive state during that time frame.
Your Honor, at this point, the state moves into evidence. I can't remember the numbers. Is it 37, 8, and 9?
37, 38, and 39.
Please.
And I'll preserve the defense objections previously made. Are there further objections that you wish to place on the record?
No, Your Honor, to all of which I do object.
All right. I'm going to admit states exhibits 37, 38, and 39 over the defense objections.
Your Honor, the state has no further questions.
All right. Cross-examination, Mr. Victor.
Mr. Heinzman, the purpose of your testimony here today is to demonstrate that Michael Cochran, and this is an old story, was duped by my client, Natalie Cochran, and didn't know anything about these contracts, right?
Yes.
Now, and for that matter, the other message there that you are telling the jury about is that Natalie Cochran was involved in the illicit business of contracts. Is that right?
Yes, that's correct.
Would you agree with me, sir, that throughout this trial, as you were sitting here, we have conceded that Natalie Cochran was a bad girl and she was dealing in those federal contracts? Did we concede it or not?
Did you concede to it? I don't know who we is.
Listen carefully. Is it true that Natalie Cochran has conceded that she was involved in the fraudulent scheme?
Yes, she
So
did.
that shouldn't be any surprise for you when you look at all these documents. That she is involved in these transactions.
The purpose of my testimony was to illustrate that Michael Cochran was not involved in the illicit transactions.
Michael Cochran wasn't involved in it. All right.
Y'all, Penguin's getting
I'm going to
Penguin's
ask you-
getting it, man.
If I could do that.
Thank you, Broken Baker, for that nickname for this guy, Penguin. It does suit
Looking
him
at
well. Hello,
one of
Miss
the
Toxic. Hi,
examples-
Tammy.
Yeah.
AK Swan. Hi, everybody. I thank you for being there here, David.
I do not recall which.
David, tomorrow
Um,
we'll be back to the
number
other
it
trial. If
was.
it's a live one. If
I think it's somewhere
they
around
have
5 or 6. But you testified about this document, didn't you?
Yes, I did.
That document was telling you that on August the 30th, and I presume 2018, $1.2 million was going to be posted, right?
Wow, that's a lot of money.
See it there?
On
How much
August
did she
30th,
scam
yes.
people
Yeah.
for? Do y'all know?
Posted in the account of Mr. and Mrs. Cochran, right?
Yes.
Then on September the 4th, I'm sorry, the 3rd, $724,000 was going to be posted. May not be the 3rd because it's going to be a holiday, but it was going to be posted in the Cochran's account, right?
Yes.
Wow.
And then
Millions. Wow.
$2.56 million next Friday was going to be posted in their account, right?
Yes.
How did they come up with all this money?
Well, comes August 28th, no money in the account, right?
Correct.
Comes August 29th, no money in the account.
Correct.
Comes the end of September, no money in the account, right? Right?
Yes.
Yes. Will come about that $2.6 million next Friday. So that's probably sometime, I don't know, sometime at the beginning of September, right? No $2.6 million coming.
Correct.
And Mr. Cochran doesn't know that. He is waiting for about $4 million, right? Right?
The last date put out on these is December. So between August 27th and December, it was over $300 million that he was
I
told
asked
was
you
due.
about these numbers: 300,000, $1.2 million, $724,000, $2.6 million. There's nothing about December there, is there?
December 21st on the next one down. 12/21, $131 million on 12/21.
I didn't ask you about that, sir. I asked you about the top,
Okay,
the exhibit. There's about $4 million coming to Michael Cochran, to his account, right?
to the business. Yes,
To the business where Michael Cochran is a minority owner, right?
no,
Now, to the business where he has a joint account, right? Yes, sir, yes or no?
yes,
Yes. $4 million coming to my account, and I don't know anything about it?
that is correct. Well,
And
he knows what's been told to him
Okay.
here about the
Well,
$4 million.
fine. Then let me ask you this. We are now at the beginning of October. That $4 million didn't materialize itself.
Thank
is
you,
not
Toxic. We'll
Asking
go there in a
questions,
minute.
Is he?
He absolutely is. The defendant had
is?
produced an audit
Show me in
ruse,
any of these documents, sir.
an audit
When-
ruse.
Show me any of these documents, these exhibits. When he is asking any questions about where is that $4 million?
We
Where
have,
is that $4 million? Show me any of these documents here that were admitted into the evidence, not some stuff about we did our investigation. Show me in any of these documents.
if you'll hand the documents back, I'll review them to see if I can find that.
You can review them all you want.
But
Here we go.
I know that throughout the text messages that were reviewed, 1,224 pages of text messages are
I don't care about this.
numerous times that Mr.
Show me-
Cochran
show the
asked
jury.
where the
Mr.
money
Heinzman,
was at.
Mr. Heinzman, there's no question pending. I'm asking you to show this jury from these documents that Michael doesn't know, that Michael somehow is not surprised that the $4 million that was supposed to come to him at the beginning of September is not there. Show me.
He had been
Show
told
the
it
jury.
wasn't coming because of an
No,
audit.
No, sir. You look at these documents, show me if there is anything in these documents that indicate that Michael Cochran is or is not surprised by not getting $4 million.
Your Honor, do me take the time to review all these documents? And
Well, if you can, go ahead, Mr. Heinzman.
I'll move quickly.
All right.
While he does that, let's
And I'm looking
go.
specifically for where is that $4?
Why can't I show this? What? Why is that not showing, y'all? Thank you, As a Gavel Drops, for partnering with us on our channel here. We depend on you for all of our document needs for courts, hearings, and other trials. If you love to dive in and read court documents and learn things for yourself, please go to Discord over to As the Gavel Drops, verify your account, which is a must. You too can have access to all the documents that we use on this channel. But remember, if you use them in a live or a public place, please give credit to As the Gavel Drops. They have fabulous mods. They are covering almost 500 cases at this time. Enjoy. Yeah, 135 months is a long time for fraud charges, that's for sure.
Would you restate your question?
Well, show me in any of these documents when Michael Cochran is asking
That's 11 and a quarter years.
Natalie,
Y'all like Mr. Penguin,
or
huh? Thank
anybody
you,
for
Broken
that
Baker,
matter,
for that.
where is that $4 million or, well, 300,000, 3.4, well, there's more than that. 300,000, $1.2 million, $724,000, and $2.56 million. Where is it? It was supposed to be deposited. Now it's September, it's October, it's November. Where on earth is that money? Show me any of these documents.
Show me the
indicating
money.
his inquiry about that.
Show
Okay.
me the
On page
money.
19, he's referencing the 1.6 million, having to wait for that. On
Okay.
page 20, when she says she's on the phone with Bank of America, he's asking, are we 1,000%? Because she's told him at that point that the money is at Bank of America.
Okay.
On page 21, he says, this is February 4th, the day that 3 days after he expected the money.
It's like,
He tells her that the money isn't there. She provides additional excuses for that.
okay, this is not self-unaliving in sign language. This is, okay, this is like mind blown. Sometimes we do this. And you do the face. That was the longest opening, and she ain't done yet. I want to know what the longest opening statement is in the history of trials.
And then on page 22, dated February 4th again, she's telling him that the 88 million and 297 million will possibly show up today.
Not she's telling him.
4.8 million in the morning and 23.8 tomorrow. Again, another delay, and his response is shit.
All right, okay. Show me,
Well, you said that very well.
Let me go through the rest of the documents.
hold on. Show me when there is gonna be $108 million to be deposited in the account
$108 million.
It's right there on August 27th on the text that's being provided.
and $100
Yo.
to be deposited in November and in December.
Yes, it's right there on the text.
And he doesn't know that this money ain't there?
Good
No,
point.
He
He-
believes this money is coming. What's significant about August
No, I didn't
27th?
ask you. You seriously?
I can explain.
Hold on, sir.
Okay.
Are you seriously contending before this jury that he doesn't know that that $239 million is not there?
I'm telling
Yes or
this
no, sir?
jury that
Yes or
Michael
no?
Cochran does not know.
Yes or
if
no,
he
Your
believes
Honor?
that money is
Your
coming.
Honor, I'm sorry. Say yes or no.
Well, he's trying to explain, and I think we should let the witness explain his answer. Go ahead, Mr. Heinzman.
Yay!
Michael Cochran has been led to believe that all this money is coming to their accounts for government contracts, and it never comes.
And I presume that in September, October, November, December, and January, he lives in the same household as Natalie Cochran, right?
Yeah.
He does, yes.
He certainly doesn't live on another planet. He can talk to Natalie Cochran about these contracts on a daily basis.
I love the way this
He can
guy,
talk to her. Can he not?
Yeah, he does.
his accent and the
does.
way he says
And
it's funny.
he, on August 20, whenever, September, honey, where is that 8 million or $4 million? And she's lying to him, right? Is that your testimony?
And she says, we're getting hit with an audit. Can you believe it?
On September 5th, she's telling him, oh, no, that money is coming, right? On September 6th, 7th, 8th, 30th, October, he is somehow duped by it. And he's so blind to it that he will not ask his wife, where is $238 million? And he naively and blindly believes that this money is going to be there and it ain't there. Is that what you're testifying to, detective?
Absolutely.
It's not what you're testifying to, detective.
Show me.
Show me the
There's
money.
nothing in these documents.
I'm really getting
talks about
sarcastic with this show me the money
Michael's
crap.
computer. Is there?
Not
Michael
in these
arranging
documents.
for these contracts on his computer as he's sitting in the bedroom while Natalie is watching TV and the kid is between them. Those documents don't deal with any computer operations of Michael Cochran, right?
No, they do not.
Okay. Those documents did not deal with any personal contacts that Michael Cochran had with the investors, including his own mother. Correct?
These documents do not.
These documents do not
Which does
deal
not
with
look like
any
the other.
checks that he wrote, as we saw in some of the exhibits here, on behalf of the companies. Correct?
Correct.
For either services rendered or for consulting services, et cetera, right? These
Correct.
documents don't show that. These documents
Oh,
don't, these documents do not address any issues that, the detectives are coming and, maybe they should talk to the kids Is there anything about that anywhere?
No, that wouldn't be anything like that.
All right. These documents, of course, do not deal, again, in the same old story, with the lifestyle of the Cochrans, right?
These documents do not.
Honey, I'm taking you to Paris and I'm gonna get you a Louis Vuitton bag for
Oh,
God only knows how many thousands of.
okay, you guys. Ladies, my dear friends, did you not hear how he said Louis Vuitton? That is the proper way to say it. I want to hear it one more time. Louis Vuitton. I can't do it properly, but he can.
These documents do not.
Honey, I'm taking you to Paris and I'm gonna get you a Louis Vuitton bag
Vuitton
for
bag.
God only knows how many thousands of dollars. Because we have
Louis
somebody else's
Vuitton
money
bag. That was
to live
priceless.
high on a hog.
Yeah,
These
right.
documents don't deal with that.
I don't ever want a Louis Vuitton bag. I don't want one.
Not that depiction, no.
No, not that depiction. Well, they don't talk about any of the wealth that the Cochrans, plural, have acquired through the illegal schemes and enjoyed for a long time.
I don't
Right.
even know how to spell it, much less
These
say it.
documents do not.
I
These
ain't that
documents
rich.
don't deal with anything about Michael Cochran's health. Honey, I feel bad today. I'm declining, or anything.
Who
of that
uses
nature.
declining?
There are references
Yeah,
to him
no,
being
how
stressed.
come?
because
Oh
of
my
the
gosh.
Lack of money.
He is stressed because he doesn't know.
In these documents I'm referring to.
He's like in a National Enquirer. We want to know, right?
Oh my
wants to know.
gosh, he's throwing it all
Right?
there. He's throwing it
He wants to know where
all.
the money is that they've earned
wants to know.
through what he believed was
I love this
legitimately
guy. I
awarded
do.
government
Right.
contracts.
And yet he goes to a boat sale and buys himself 2 boats at the same time, right?
2
I
boats
don't
at the
know if he went to a
same
boat sale.
time?
I know that
Are you
he did
absolutely
purchase
insane?
ATVs, boats, vehicles,
Right.
things of that nature that both he and his wife picked out based on text messages we read, or by her encouragement to make purchases because she had led him to believe that they had all
Sure,
this
she let him to
wealth.
believe. And you truly believe it.
Absolutely.
All right. These documents do not show, these documents that deal with Natalie only, not Michael, whether he was copied on them. Do they?
So would you ask that again?
No, you
please?
look at any of these documents where Natalie is talking to Miss Petite or Chris Davis, where Mr. Cochran is not involved. Is there any indication that he is copied on those conversations?
Some of them, yes.
Yeah. So some of this he knows, right?
Some of it, but
Yeah.
not in this context that you're framing it.
Not in this context, of course. Okay. Now, when he talks on some of those messages, the jury will probably see that those conversations take place after Michael's
Enough.
death, right?
Yes.
So he cannot contract anything, Mr. Heinzman, because unfortunately he's passed away, right? Right?
Yes.
And Natalie Cochran is continuing the scheme that she was involved in, but it has nothing to do with what Michael knew and what he didn't know because he's dead. Right?
No, it supports the fact that it was her scheme because she continued it on.
It support. Well, one of those exhibits, Michael asked, no, 16. Michael asked directly to pull out $9,500. From where?
From their personal account
To do what with it?
to have some cash on hand.
And that $9,500 came from where? They didn't have any income, independent income. That must have come from the investors, right?
That or rescue loans.
Well, is it possible that since they have no income, independent income, you testified that Natalie wasn't working as a pharmacist anymore, and Michael's job was an IT man, not really defined, that he's pulling $9,500 in cash that must have come from the investors, right?
Yes,
So he pulls $9,500 that he considers money earned, right?
from previous
If
contracts.
he right,
Yes,
if he believes that, if he's so scrupulously honest, well, he must believe that this is the money that they've already earned on those contracts, right?
right. He's not aware that there are illicit proceeds. He thinks they're legitimate proceeds.
Right.
Right.
What does $9,500 tell you as an investigator of money laundering?
Well, that
Cash. I'm gonna ask 9,500 cash. What does that tell you? You're the expert here on money laundering.
Sure. In this context, it means nothing. In the context that you're framing it, it references currency transaction reports. Those are a federal requirement under the Bank Secrecy Act.
Well, let me ask you
Where-
this. Let me ask you this. Every,
Yeah.
well, I'll ask a very specific question. Under
Well,
a-
the witness should be permitted to answer. Go
explain
ahead,
the
Mr.
$10,000
Hines.
cash.
The Bank Secrecy Act requires financial institutions to file what's called a currency transaction report for any transaction involving $10,000 of U.S. currency, that'd be cash or coin, in or out of a financial institution. It is a derivative of the Patriot Act and the War on Terrorism, so they want to track large amounts of cash. So if a withdrawal from a financial institution were to occur above $10,000, the bank would be required to complete a currency transaction report and document that transaction. In this case, however.
Well, I'm
the
sorry. Now,
Cochran
now
said
let me,
cash
I'm
inside
sorry.
a
I'm sorry,
safe.
Your Honor.
Okay,
Now the question is this.
fair enough. He's answered the question. Go ahead, Mr. Victor.
$9,500 in cash is obviously under 10 grand, right?
It is.
And he withdraws that amount of money in cash, right?
Yes.
Would you agree with me that he does that for the purpose to avoid the $10,000 money reporting necessity?
No, I would not.
No?
That's not illegal. It's not an illegal act. It's when that is anything 10,000 or more is
Right.
taken out in multiple increments over a short period of time. That would then trigger what's called a suspicious activity report
Right.
with the bank that ties back into the currency transaction. report.
And
So
that's why-
that amount alone is not illegal.
And that's why he's taking $9,500 rather than 10,000, because he would have to report it to the IRS.
Your Honor, that's speculation. There's no way the
Wow.
witness could read the
Sustained.
defendant.
All right. What about those income tax returns that the parties filed jointly?
Those were prepared by Natalie
can't get
Cochran.
my
They
ice
were
cream
false
open, y'all.
documents.
They were false documents.
Yes.
And he signed off on them.
There was no signature by Michael on the documents.
For 2017,
No, there was not.
2018,
No, there was not.
2019.
No, there was not.
And you're telling this court that she filed taxes and he didn't know anything about the income tax returns.
That's correct.
So he himself broke the law by not filing income tax.
If he had known what was being filed,
If he had known, he would have filed taxes.
no, if he had known what was being filed.
Okay. So he didn't have to sign the income tax return because his income was zero? Why didn't he have to file income tax return with Natalie?
I'm not saying he didn't have to.
Why didn't he sign those?
Because they're done electronically now, you don't even have to sign them. One person could fill them out and file them electronically. He doesn't have to sign it. Now, the law requires that all tax preparers review their documents that they're filing, but
And he reviewed them and he had absolutely no idea what Natalie was doing with the taxes and with the bank losses and with, well, the business losses, the business gains, et cetera, et cetera.
I have no idea if he reviewed them. If he had, he would further believe that he had made an extraordinary amount of money on
Show me,
government contracts.
show me here any income tax return that lists about
If this guy says, show me one more time,
by the
I'm going to
Cochrans.
show
Can you do
him.
that? Can you show this jury?
Show.
No, I cannot. I don't have the discovery files and records with me to break
From
out to break out the tax returns that we did recover.
From your thorough investigation of this case, because you said that several times, was there ever an income tax return filed by the Cochrans that would list $239 million? Can you tell the jury that?
I know that there are tax documents that were given as ruses to get bank loans.
From your memory, Mr. Heinz.
But I cannot say if that figure that Mr. Victor has given
This
me
is a vanilla
matches
fudge
those
cookie
documents.
gelato.
$239 million. Would that raise some red flags if you ever saw an income tax return from a small West Virginia company filed with the Internal Revenue Service? Would that cause you to pause and consider that?
In what context?
Well, somebody's making $239 million from a business and files that income tax return. I would like to know the details of it.
Are you talking about the IRS would want to know the details, or?
Well, you were investigating their.
I've already answered that question. If I saw that, it's another prop. It's a ruse. It's not unsubstantiated by financial records, income records, state databases, federal databases. They would just, to me, that if I saw that.
So you have
it would
no
be another
idea.
prop.
So you have no idea as you sit here today to tell this jury how much money Mr. and Mrs. Cochran were making and how much money they were reporting. True? As you sit here right now. Can you or can you not?
It's a very broad question.
Well, how much money did they make in 2018? Can you tell this jury whether they made millions or whether they made a couple of $1,000s here and there?
2018.
Yeah.
Are we talking
Y'all,
about legal income or illegal income?
I know everybody's going off on how this lawyer is doing the cross, but he's actually doing his job. We're not supposed to like him. He's supposed to be nasty to a point. He is getting to the information he needs. He is trying to prevent information that would harm his case from coming in. He's doing his job. I just think it's funny. He looks like a penguin with a Russian accent.
Income tax return. Remember?
The income tax returns that we reviewed were submitted not to the IRS because that would have got red flags, but to people that they wanted to borrow money for to demonstrate the value of the company.
So now you're telling us that Natalie didn't file income tax in 2018?
Nope.
My recollection was that there had not been income taxes. No, let me correct that. The income tax documents that we recovered had been doctored to show greater income because they were used for other purposes. The actual income tax that was filed, which was presumed.
Yes, toxic. He is Polish. But it was funny. I was watching Broken Baker and he was talking about this guy. That's where I got the penguin from. And he said that he has more of a Russian accent than a Polish accent. That's why I said that. He is a Polish penguin with a Russian accent. He said he probably it was where he probably went to school.
Would have been legitimate. We did not review.
I see. Now, If I may have a second.
Yana, you are amazing. Yana, you're freaking amazing. Let me see if I can visit the site and I'll get it to you. Okay. QC completes longest speech in legal history. It sounds like a scene from a latter day reworking Charles Dickinson legal sire of the Black Horse. Today, lead counsel for the Bank of England will sit down after delivering what is believed the longest speech in British legal history. After 119 days talking through core trial bundle of 125 lever arc files, Nicholas Stadlin QC has finished his opening comments in the bank defense of 185 million quid compensation claim by what? Wow. I just had to share that. Wow. Hi, baby girl. Did they not give you something? Come on.
I don't
Get in
think I
here.
have any more questions of this witness.
All right, redirect Mr. Truman.
Nothing from the state, Your Honor. Thank you.
Very well. Mr. Hudson, you may step down, sir.
Thank you, Your Honor.
She smiles a lot.
All right, Mr. Truman, I'm hopeful that you can have a working lunch and maybe go through the charge while you eat your sandwich.
I'll take care of, yes, I'm on page 8.
I
Okay,
have them done.
all right, thank you.
So far, there's only been a couple little things to check on.
All right. Maybe we can come back at 1:15, so we'll have 15 minutes to make any corrections.
I think that should do it.
All right, and then
From a
we
safe
can
perspective.
start out on time. I don't want to delay the.
Okay, so they're on a lunch break, and he's got to read his charge that he should have had done already, or somehow they didn't get it. My camera is wiggling a little bit. Let me get it back where it belongs. I ate some of that gelato. Oh my gosh, now my stomach is not happy, y'all. Not happy. My stomach has been, I don't do ice cream very well. I do like gelato every once in a while, but man, I'm feeling it. Gosh, I keep seeing my braid when I turn my head on my side monitor here. Oh, for those of you, let me go ahead and take this down and big in me. I'm going to switch to camera view 4 for those of you who don't know. Hey, this is the workspace. This is, I'm very much slouchy in this chair. If I'm sitting up straight, there it is. I probably should put the pillow behind my back, but it's one of these real comfy chairs. Here is the computer, and this is my live feed, so I can see what you see. This is where I have the comments in Discord. This is the working feed. Up here is the switch feed. This is how I can switch back and forth. And then over here is the trial itself. Yep. And then I got the cell phone right here, the iPad here, the little box you can't see there with the sound effects. I got to figure out why it's not working. I got my switcher finally up and running. And of course, I got the beautiful Rodecaster Pro 2. Yes, the prosecution does seem a bit scattered. It definitely is a bit scattered. And it is a little frustrating. It's just I'm started a new. See, here's the problem too. My bangs. Let me get them. There. I've started a new medication, and I think it's causing a little bit of. I was warned that it may cause a slight irritation to the stomach prior for a day or two, so that's where we are. I'm healthy. I'm fine. Has to do with rheumatoid arthritis. So there we go. Hey, the mouse. Yeah. Hey, Zach. Zach is back, y'all. I thought I'd done piss him off. I really did.
I thought I done pissed him off. He disappeared on us. Yep, he disappeared on us. I was a little bit concerned. So this case here is in no, it's I'm brain dead. Okay, we're gonna look at something while we're on break. It is 24 pages. What about this one? That's the Natalie Cron. I don't want to do that one right now. Let me get back to as the gavel drops. We'll put it where I can see what I need to see. Yana, you were amazing. Thank you for giving me that information. Same thing for you, Toxic. Thank you so much. Please go to As the Gavel Drops. Toxic is fabulous at giving us access to a lot of amazing documents, especially with all the popular cases. Sorry, I'm trying to do two things at once. We have a new Karen Reed document that we're going to read through. They are very well, one's 13 pages, one is more than that. So what I'm going to do is I'm getting everything set. I'm going to share screen. Let's do this. Edit. It's West Virginia, not Nevada. West Virginia. Mountain Mama. Shenandoah River. All right, let me get this up and going. Oh. So if I'm trying something new, guys, if you'll just give me a second. Not tried this before. Save it to desktop. Do we have the same? No, it's not the same. Okay. So I'm trying see if this feature works in my Discord. They're going to come back, but I'm going to try. Oh my gosh, this is so freaking cool. It worked, but it's small. I can't embiggen it like I can the other way. Okay. Good to know. So we'll open those in a minute. I know we missed the fish kisser. We missed the fish kisser. I got to get this back up again. It's why can I not get this up? There we go.
Approved by the defense.
All right. Is this the same version you submitted earlier, or is it a revised version?
The one submitted this morning is that.
Yes, they are,
The
Timmy. We're
original one I
back.
Submitted a couple weeks ago was.
Okay.
That one.
I think it's could be a hung
Has been
jury,
approved by-
actually.
And it includes the lesser. included.
Okay, I'm going to have this stapled. You may have to take it in the other office to staple it.
I keep forgetting to do my swoops.
Your Honor,
Yes.
I have a minor point to discuss. May we approach? Well, since the jury isn't here,
Not here.
I was looking over the identification of the state's exhibits and the defendant's exhibits. And I believe might be a little confusion or clerical error in item number 10 and item 16. It reads an empty vial of methylprednisolone acetate injection. It's not the injection itself. It should read empty vial of injectable methylprednisolone acetate.
Okay.
I took that right off the label.
She said she took it right off the label.
I got to do Pupper's
Fine.
comfort break.
It's a
I'll be
fine.
right back.
Okay. All right. Can the defense approve the court's charge?
Final stages.
Okay.
Oh, yeah.
Okay. Check this. I think this is an older version. I don't think that's the most recent one. I think this is the most recent one. You don't want to get confused. Okay. All right, let me ask counsel, how much time do you require for argument?
Your Honor, we'll defer to the defense.
I don't know. The state has the burden of proving. Maybe the state can.
20 minutes?
Half an hour?
Half an hour?
What do you guys need?
No, I
Hey, want to do that 45 minutes?
Okay, 45 minutes.
45 minutes?
Yes, Your Honor.
Okay. Will you be doing the closing, Ms. Aker?
Yes, I will, Your Honor.
Okay, how do you want to divide your time?
$35 for closing and 10 for rebuttal, Your Honor.
Do you want a discrete 1-minute warning
I would appreciate that, Your Honor. Thank you.
on both ends?
Please.
That would give the defense the full 45 minutes if you wish to take it. Do you wish a 1-minute warning, 2 minutes, or what?
2-minute warning is fine.
Pardon?
2-minute warning is
2
fine.
minutes.
John.
All right, here's the final question I have for you. It's going to take me a little while to read these instructions because it's 18 pages. Do you want to take a brief recess between the court charge and the closing arguments, or do you wish to go on through? It's up to you.
Judge, the only thing about the instructions, I thought we were placing the involuntary manslaughter before the instructions dealing with malice.
I thought that's what we did.
Yeah, I thought so too, but it's not the case.
Judge, I think
It's page nine.
that is what we.
Proposed.
Okay.
It'd just be a matter of cutting and pasting page 10, where it starts with the definition, and moving it before the discussion of malice on page 9.
Okay. I'm going to ask you two to go with Ms. Brown Bailey and assist her so that you can set it forth appropriately.
Are we having issues with documents? Ooh, I did something I shouldn't have done. Are we having document problems? Is that what's going on? Yes, Haley Mouse, please go to Discord. Join us at Discord. Now let's see if I can reading and not spill a million seed beads everywhere on the floor like I've done before. But I did learn how to get them up pretty. Oh, dang it! Really? There we go. They need 35 minutes for clothing and 10 minutes for rebuttal with a 1-minute warning. Defense requires a 2-minute warning with the 45 minutes. Okay. Y'all being a little snippety there on y'all's request, huh? Wow.
Yeah,
Y'all, I have
very
not
much
done beading in a long time.
better than typewritten.
I got to get back into it. I got a lot of bead work that I got to get done. I got to get my own done. I have something for a customer. Luckily, she's still with us. Her hair's looking kind of cute today. What don't you understand, Tammy? I give some splaining. I got some splaining to do. So tell me what you don't understand. And that was a play on Ricky from I Love Lucy. Lucy, you got some splaining to do. Lucille Ball was inducted into the Kennedy Hall of Honors just 5 days after the death of her beloved ex-husband. And Ezzy sent a sweet letter to them to read to her in case he didn't make it. And I thought it was so sweet. You know, sometimes you can't live with somebody, but you still love the hell out of them. And that was definitely the two of them. Definitely was the two of them. I was an I Love Lucy nut as a kid. Yeah, they're just prepping for closing arguments right now, which is fine. Hopefully their closing arguments really won't go like the opening arguments in the other case. But I want to thank all of y'all for joining. I know it's kind of quiet right now in the courtroom. It's not a bunch of drama, which is normal. But I guess what we could do while they're doing that is I could start reading some of the Karen Reed stuff. Anybody want me to read some of the Karen Reed stuff? We got new Karen Reed documents. Yes, we did. Thanks to As the Gavel Drops. We sure did. We did. But I got to figure out which one comes first.
They look to be the same. March 11, 5. 1105, 1105. So that is different than that. Which one comes first? I don't know which one to read first, y'all. Okay, so that's the deny. Okay, we'll read this one first. Let me get these two on a different screen so I can have more reading room. Okay. Let me try and get this up on screen. And there we go. Okay, we're going to read this while we wait. All right, here we go. Now I got to cover these beads because they're right. They're like little grains of. It's not focusing. See how little they are. I've already had one nightmare. Don't need another one. If y'all been around, you know. I Love Lucy is what caused me to learn closed captioning. A deaf friend stopped by while I was. Oh. She'd never seen it with closed captioning. Haley Mouse. Yep. Okay, so I got the court feed on, and then when they start, we'll get it. Okay, let's go. An affidavit of Richard Green in support of the defendant's opposition to the Commonwealth motion to exclude certain testimony from the defense. Okay, so I need to actually be over here on this document first because this is their answer. Let me get it centered. The defendant's opposition to Commonwealth's motion to exclude certain testimony of the defense witness Richard Green. Now comes the defendant, Karen Reed. Miss Reed, and respectfully requests that the Honorable Court deny the Commonwealth's oh, maybe I was right. Oh, yeah, I am right. Okay, to deny the Commonwealth's motion to exclude expert testimony from Richard Green. It's a lip gloss because I'm reading and it's going to dry out. As one, his expert opinion. Let me do this. Y'all know me. I gotta. Okay. One, his expert opinion that, that ain't gonna work. Never mind. Why can't things work easily for me? This is irritating. Expert opinion that Google search for "has long to die in cheek" or "has long to die in cold" was made by Jennifer McCabe on the phone at 6:23 a.m. January 29, 2020. So right now they're conceding that it was made at 6:23. And two, his expert opinion that Jennifer McCabe's phone incurred other deletions of any data related to Google search and deny the Commonwealth included request for an evidentiary hearing under the standards of the step forth by the Dalbert Merrill Dow Farms. Let me see. The judge is in the room, but they're not talking. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy the Daubert Langen. Instead, the Commonwealth entire motion merely addresses the conclusions and opinions of Mr. Green. Matter of the court resoundingly states that the subject for cross-examination in the jury, not the function of the Daubert-Langland jurisdictional gatekeeper. Moreover, the opposition can clearly demonstrate that Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. So now I'm going to come back up here.
Voluntary manslaughter with the definitions of malice. Is that correct, counsel?
Correct. Your Honor.
Yes, Your Honor.
And we haven't changed the wording of anything. We've simply moved those segments around as indicated.
It was a cut and paste. Yes, sir.
Yes, Your Honor.
All right. That's agreeable, certainly, with the court. That's what we discussed. One more thing. Do either of you wish to have the podium set up in front of the jury box?
Yes, Your Honor.
All right. I'll ask the bailiff to do that, please.
And Your Honor, while we're doing that, after some reflection, I'm thinking I might need a little more time for closing. If we could have an hour total, I won't need that long, but I think mine will probably run about 45 minutes on its own.
All right. So you'd like to have an hour altogether?
Yes, Your Honor.
And how do you want to divide that?
45 and 15.
Sure.
45 and 15, Your Honor.
You still would like to have the 1 minute warning?
Yes, please.
And that would afford to Mr. Victor a full 60 minutes. Is that agreeable?
Yes, sir.
With the 2 minute warning?
Yes, sir.
Thank you, Ronnie, for the documents. I hope your husband is getting ready for surgery well. Ronnie's
All right,
husband is
are
going to
we
have
ready
knee
for the
surgery.
jury?
Ronnie's husband is going to have knee surgery. I believe they are in the process of scheduling and doing all the preliminary workup on that. So keep them in your prayers, please, or good vibes or good thoughts or whatever it is you do. Here we go. Closing arguments.
Yes, Your Honor.
Bring in the jury, please.
I don't like your tone. I like this one.
May bring the jury.
Okay. I think that's probably a good idea.
That to me looks like a very nervous smile when you're kind of like, that doesn't look like a confident smile to me. I believe that is her parent. Those are her parents behind her. I understand parents supporting their children, but if my son unalived my son or daughter had an unalived their spouse, I don't know how supportive I could be. I'd love them. That my love will never go away, but I can't support. So I don't know. I don't know what I'd do in that position.
Jury is present.
Members of
Thank
the
you.
jury,
You may
the next
proceed.
phase or stage of this case, as I touched on earlier, is the instruction of the law by the court. I can tell you that this is a very boring and tedious part of any trial. And perhaps some of you who have served as jurors before know that very fact. Sadly, you must pay strict attention to what I tell you. Your oath requires you to apply the law that I will state to you to the facts you determine from the evidence. So this is a very important stage or part of any trial. Members of the jury, you have now heard and seen all of the evidence in this case. You are the sole judges of that evidence
Permissible
and the facts
evidence in
that
the
it
case.
establishes. It is your sworn duty to determine and base your verdict only upon that evidence. In doing so, do not be influenced by sympathy, anger, passion, prejudice, or public sentiment. It is now my duty to inform you about the law that applies to this case. You have no right or privilege to disregard these instructions or to form a different opinion about what the applicable law is or should be. All of these instructions are important. Do not pick out one part and ignore other parts. You are to draw no inference from the order or manner in which they are given, and they are to be considered by you in their entirety as a whole. The indictment in this case is merely an accusation, and it is not any evidence of guilt. The burden is on the state to prove the guilt of the defendant beyond a reasonable doubt. The defendant is not required to prove her innocence. Our law presumes a defendant to be innocent of crime. So the defendant, although accused, begins the trial with a clean slate with no evidence against her. And the law permits nothing but legal evidence to be considered in support of any accusation. So you see, the presumption of innocence alone is sufficient to acquit the defendant. You must determine the facts of this case from the evidence only, that is, from the testimony of witnesses and exhibits. Disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. Absolutely nothing that I have said or done during this trial is to be considered by you as evidence or as any indication of an opinion concerning the weight of the evidence, the credibility of the witnesses, or the guilt or innocence of this defendant. Nothing that I, as judge, said or did at any time during this trial is to be considered by you as evidence of any fact or as an indication of any opinion as to any fact or evidence, or as a measure of the credibility or truthfulness of any witness who testified, or as to the weight you should give to such testimony, or as to what your verdict should be in this case. For you are the sole judges of such matters, and I am only the judge as to the applicable law. The evidence from which you are to determine and base your verdict consists of the sworn testimony of all of the witnesses, regardless of which side called them as witnesses and whether their testimony occurred on direct or cross-examination. The exhibits that were received into evidence, regardless of who introduced them into evidence. Any facts which I have told you were agreed upon by stipulation or otherwise, and any fact which I took judicial notice of. However, if you do not agree with that fact, you are not bound to accept it. Members of the jury, there are two basic kinds of evidence, direct and circumstantial. Direct evidence is testimony as to what a witness saw, heard, or did. Circumstantial evidence is indirect evidence, that is, it is the evidence of a fact from which another fact, not directly testified about, can be inferred or found. Both of these kinds of evidence may be considered, and it is for you to determine and decide whether or not a fact has been proven by circumstantial evidence by considering all of the evidence in light of reason, common sense, and experience. There is no quantitative difference between direct and circumstantial evidence. The following elements are not evidence, ladies and gentlemen, and you are not to consider them as evidence for any purpose whatsoever. Anything that any of you have seen or heard outside of the courtroom or when court was not in session. Do not consider or be influenced by any testimony or evidence which has been excluded and not put into evidence, and do not consider or be influenced by any testimony, evidence, or any other fact or subject that I instructed you to disregard and not to consider as evidence. If during the trial I instructed you to consider certain testimony, evidence, or facts only for a particular or limited purpose, You are to continue to do so and must consider such matters only in that manner and for that limited purpose. Do not be influenced by or draw any inference from any objections that were made by the lawyers during this trial or my rulings upon such objections, for such matters are not evidence. As I have explained to you throughout this trial, statements or arguments made by the lawyers are not evidence and are not to be considered by you as evidence, for the lawyers were not and are not witnesses. What they said to you in their opening statements, or what they will say to you in their final closing arguments, or at other times, were and are made to aid you in following, determining, and interpreting the evidence as it relates to the issues before you and their respective sides of this case. While you must carefully consider the testimony of each and every witness and not disregard or overlook any testimony, witness, or evidence, the jury is the final judge of the credibility of the witnesses and the weight
I
of
don't
the
think
evidence.
so, but I'm not
The number
sure.
of witnesses testifying on one side or the other of an issue is not the only test of weight and credibility. If you feel that the evidence justifies it, you may believe one witness over a number of witnesses testifying differently. The test is how truthful is the witness and how convincing is the testimony in light of all of the evidence and circumstances shown. As jurors, you are also entitled to draw reasonable inferences and make reasonable deductions from any of the testimony or other evidence as you come to believe are justified in the light of reason, common sense, and experience.
I poked myself.
If you come to believe that any witness did not tell the truth about any material fact after carefully weighing and considering such testimony, you may disregard it or any part of it, or give to it or to any part of it such weight and credit you determine it deserves. In weighing and crediting the testimony of any witness, you may consider the good or bad memory of the witness, the interest of the witness in the outcome of the trial, the relationship of the witness to the parties involved in the case or to other witnesses, the attitude and manner of testifying of the witness, the opportunity and means or the lack of opportunity and means of the witness to learn and to have knowledge of the matters about which he or she have testified, the reasonableness or unreasonableness of the testimony of the witness, the intelligence of the witness, the appearance of bias or hostility or friendliness or unfriendliness of the witness to the parties involved in the case or to any other witness, and any contradictory acts or statements of any witness that you determine were done or made that served to contradict the testimony of such witness in court. From all such factors and considerations that appear from all the evidence and circumstances shown in the case, you are to evaluate the testimony of all of the witnesses and the weight to be given to their testimony and determine the credit you believe it is entitled to receive. In this case, you have heard testimony by witnesses who are presented as experts, who by knowledge, skill, experience, training, or education had acquired scientific, technical, or specialized knowledge in the field or area about which he or she has testified. As an expert, he or she is therefore entitled to express an opinion upon matters within his or her field or specialized knowledge and to state the reasons for an opinion. Expert testimony is to be considered and evaluated as you would the testimony of any other witness. You may accept or reject it in whole or in part, or give to it or any part of it such credit and weight you come to believe it deserves. In evaluating expert testimony, you should consider the knowledge, skill, experience, training, and education of the expert and the basis and reasons given for his or her opinion in light of all other testimony and evidence in this case. The court instructs the jury that evidence of other crimes, wrongs, or of acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. This court has taken judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has taken as fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. The offense charged in the indictment in this case is murder of the first degree. You may return one of two verdicts pertaining to murder of the first degree under the indictment. They are 1, guilty, and 2, not guilty. Murder of the first degree is any felonious, willful, malicious, deliberate, premeditated killing of another person. Murder of the first degree consists of an intentional, deliberate, and premeditated killing, which means that the killing is done after a period of time for prior consideration. The duration of that period cannot be arbitrarily fixed. The time in which to form a deliberate and premeditated design varies as the minds and temperaments of people differ and according to the circumstances in which they may be placed. Any interval of time between the forming of the intent to kill and the execution of that intent, which is of sufficient duration for the defendant to be fully conscious of what she intended, is sufficient to prove a deliberate and premeditated killing and to support a conviction for first-degree murder. Before the defendant can be convicted of murder of the first degree, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that 1, the defendant Natalie Page Cochran, 2, in Raleigh County, West Virginia, 3, on or about the 11th day of February 2019, 4, feloniously, willfully, maliciously, deliberately, and unlawfully and premeditatedly slayed, killed, and murdered 5, Michael Cochran. After impartially considering, weighing, and comparing all of the evidence, if the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of murder of the first degree, you may find Natalie Page Cochran guilty of murder of the first degree as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of the elements of murder of the first degree, you shall find the defendant Natalie Page Cochran not guilty. Involuntary manslaughter is committed when a person caused the unintentional death of another person. This court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is the main element of involuntary manslaughter. A person is guilty of involuntary manslaughter when a person commits an act in a grossly negligent manner and unintentionally causes the death of another person. Therefore, in order to find the defendant, Natalie Page Cochran, guilty of the offense of involuntary manslaughter, the state of West Virginia must overcome the presumption of innocence and prove beyond a reasonable doubt each and every one of the following elements. 1, that the defendant, Natalie Page Cochran, 2, on the 11th day of February 2019, 3, in Raleigh County, West Virginia, 4, unintentionally, 5, caused the death, 6, of Michael Cochran, and 7, against the peace and dignity of the state. If each and every juror is not convinced beyond a reasonable doubt that the state of West Virginia proved beyond a reasonable doubt each and every element of the offense of involuntary manslaughter, the jury must find the defendant, Natalie Page Cochran, not guilty. Malice is a subjective state of mind of the defendant. It may be proven by evidence of circumstances surrounding the crime, such as words or conduct of the defendant before, during, and after the event, or evidence of ill will or a source of antagonism between the defendant and the deceased. Also, malice may be inferred from a deliberate cruel act, indicating a heart disregarding social duty and fatally bent on mischief. Malice and intent also may be inferred from the defendant's intentional use of a deadly weapon under circumstances
Hey there,
which the
Journey to
jury
Justice.
does not
Hello,
believe gave
love.
her legal excuse, justification, or
Appreciate you being here.
provocation for such conduct. Malice may be expressed to include not only anger, hatred, and revenge, but other unjustifiable motives. It may be inferred by you from all of the evidence in this case if you find such inferences reasonable from the facts and circumstances in this case, which have been proven to your satisfaction beyond a reasonable doubt. Malice may be also inferred from any deliberate and cruel act done by the defendant without any reasonable provocation or excuse, however sudden. Malice is not confined to ill will toward any one particular person, but malice is every evil design in general. It is not necessary that malice must have existed for any particular length of time, and it may first exist at the time of the killing or at any previous time. As a defendant is presumed innocent of the charges brought against her, she does not have to prove herself innocent and is not required to call any witness or produce any evidence. She is also not required to take the witness stand and testify, for she has a constitutional right not to do so. The fact that the defendant did not testify is not any evidence against her, and you shall not consider that she did not testify or draw any inference from that fact as to the guilt
I
or
have a
innocence.
question. All right, guys, this is a good question. Break up the mundane of his reading. If you're sitting on a jury and somebody chooses not to testify, are you able to not hold that against them? Especially when their testimony, especially when you believe it's needed to bring you to a place of a decision. If you believe it would help you more, I'm just kind of curious on that. What do you think? How do you believe? Is it something that you cannot use against them, or is it something that would weigh on your heart? I'm popping beads. When I load too many beads, sometimes I have to pop them out. It's easier to pop them out than try to rethread or unthread it. The attorney, or was it the DA? Who had the accident, and do we have any information on it?
Of the charges brought against her. You must entirely disregard it and not discuss it. The court reminds the jury that throughout this trial, the state maintains the burden of proving the defendant's guilt of the crimes charged beyond a reasonable doubt.
Somebody had an accident.
From time to time during this trial, it was necessary for
That's
me
what's
to
being
talk with
said
the
anyway.
attorneys out of
I don't have
the hearing
100%
of the
proof
jury,
on that.
whether by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Most of these conferences involve determinations as to whether evidence is admissible under the rules of evidence. It is appropriate to take these matters up outside the presence of the jury. If I concluded that a more prolonged discussion was necessary, I may have excused you from the courtroom. You've heard evidence concerning alleged conduct or other acts of the defendant, Natalie Page Cochran, which are not charged in the indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charges. This evidence is admitted for a limited purpose only, and it may be considered by you in deciding whether a given issue or element relevant to the present charge has been proven. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. In this instance, the evidence of the defendant, Natalie Page Cochran, alleged criminal acts of the, quote, Ponzi scheme, unquote, may be considered only for the purpose of determining whether the state of West Virginia has established the motive to perpetuate the first-degree murder. You are instructed that upon the trial of this case, if reasonable doubt of any fact necessary to establish the guilt of Natalie Page Cochran, the defendant, as charged in the indictment, be raised by the evidence or lack of evidence, such doubt is decisive and the jury must acquit the defendant, Natalie Page Cochran. You do not have to believe that the defendant, Natalie Page Cochran, is innocent of the charges against her in order to find a verdict of not guilty. Your verdict of not guilty only means that the state of West Virginia has failed to prove to you the guilt of the defendant, Natalie Page Cochran, beyond a reasonable doubt. The jury is instructed that the mere presence of the defendant at the place of the alleged crime or crimes does not in and of itself indicate participation of the defendant in the criminal act or acts. The defendant's mere
that's a first.
presence
Have you heard that before? The mere presence of the defendant does not mean that they committed the acts. Wow, I don't recall. I just don't recall hearing that.
the scene of a crime or mere knowledge that a crime is being committed is not sufficient to establish that the defendant committed the crime charged in the indictment unless you find that the defendant was a participant and not merely a knowing spectator. The state of West Virginia must demonstrate to the jury
I like the way
beyond
that
a
was said.
reasonable doubt a nexus
Prosecutor, what
between
are
the
they saying,
defendant's
Journey?
presence at the scene of the crime or crimes at the time or times of the alleged
JTJ, what are
crime
they
or
saying?
crimes and her participation in the criminal act or acts. In relation to any and all charges contained in the indictment in this case, if each and every member of the jury is not convinced beyond a reasonable doubt as to each and every element of the offenses charged, the jury must find the defendant not guilty. If the jury has a reasonable doubt as to the grade of the offense of which the defendant, Natalie Page Cochran, may be guilty, the jury shall resolve that doubt in favor of the defendant, Natalie Page Cochran, and find her guilty of the lower grade. If the jury has a reasonable doubt as to whether the defendant, Natalie Page Cochran, is guilty of any offense, the jury must resolve that doubt in favor of the defendant, Natalie Page Cochran, and find the defendant not guilty.
Good thoughts and prayers.
Evidence relating to any statement alleged to have been made by the defendant, Natalie Page
I drew
Cochran,
blood.
outside the court and after a crime has been committed should be considered by the jury with caution and weighed with great care. All such statements should be disregarded entirely unless the other evidence in the case convinces the jury beyond a reasonable doubt that the statement was made knowingly and voluntarily. In determining whether any alleged statement alleged to have been made by the defendant, Natalie Page Cochran, outside of court after a crime has been committed was knowingly and voluntarily made, the jury should consider the age, training, education, occupation, and physical and mental condition of the defendant,
bled on
Natalie
my
Page
work.
Cochran,
I left my
and all
DNA.
other circumstances surrounding the making of the alleged statement. The jury may give the statement such weight as the jury finds it deserves under the circumstances. The test for the burden of proof in a criminal case is beyond a reasonable doubt. This means that after considering all of the evidence, if you have a reasonable doubt of the accused's guilt, then you must find her not guilty. You must always remember there is no burden upon an accused to prove anything. It is the state who has the burden to prove the accused's guilt. One never has to prove one's innocence. You must give an accused person the benefit of any reasonable doubt you may have from the evidence or from the lack of evidence, but remember the doubt must be a reasonable one. This means that it must be founded on reason and should be explainable, not a dreamed up or fancied one with no basis. The test is not beyond a shadow of a doubt, nor beyond all possible doubt. It is beyond reasonable doubt. After hearing and considering all of the evidence, you are satisfied that based upon the evidence you have in your heart an abiding conviction of the truth of the charge, then you are convinced beyond a reasonable doubt. It is your duty in this case to apply the law as given to you as a whole in the form of these instructions to all of the evidence in this case. In that regard, the court has instructed you on your role in determining the credibility of a witness and the weight of the evidence. The court has instructed you on the difference between direct evidence of a fact to be proven and circumstantial evidence of a fact to be proven. You must never convict a person unless the facts justify it, but you should not shirk your duty when the facts do justify a conviction. You must require that the state meet its burden of proof, but you must not make the state's burden an impossible one. The burden is always on the state to prove guilt beyond a reasonable doubt. This burden never shifts to the defendant, for the law never imposes upon a defendant in a criminal case the duty of calling any witnesses or producing any evidence. A defendant is never to be convicted upon mere suspicion or conjecture. To convict, you must be satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. So if the jury has, after a careful and impartial consideration of all of the evidence, a reasonable doubt that the defendant is guilty of the charges, it must acquit. If the jury views the evidence in the case as reasonably permitting either of two conclusions, one of innocence and the other of guilt, the jury should, of course, adopt the conclusion of innocence. In the trial of a criminal case by a jury, the law contemplates the concurrence of 12 minds and any verdict returned, whether guilty or not guilty. Each individual juror must be satisfied beyond a reasonable doubt of the defendant's guilt before he or she can consent to a verdict of guilty. If each and every individual juror has a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. The jury is no place for unreasonable pride of opinion or for stubbornness. While no juror should yield a conscientious opinion deliberately formed after a full and fair investigation of the case, nevertheless, it is the duty of every juror to consider all of the evidence of the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind and to give careful consideration of the views of fellow jurors, and if it can be done without sacrificing conscientious conviction, agree upon a verdict. Ladies and gentlemen, that concludes the reading to you of the court's charge or the instructions of the law. We're going to take a very brief recess so that the attorneys can collect their thoughts, and you will hear shortly from them in terms of their closing remarks or closing argument. I warn you, we are not yet to the deliberation phase of this case. After the lawyers deliver their closing arguments, you'll be able to fully and fairly deliberate on this case. But at this juncture, you cannot discuss the case among yourselves or with anyone else. I contemplate perhaps a 5-minute break, and you will return to the courtroom and we will proceed with closing remarks. You may go with the bailiff now briefly to your jury room.
And there you have it, ladies and gentlemen. And they're off. No. Oh, I got to get my clock up. I downloaded a clock, but I can't share it. It sucks. I can't share it. but I do have, I don't know why I can't share it. I don't know how to get my thing to do that.
For 5 minutes.
But I go here. I'm going to go to stopwatch. There we go. For you, those of you who haven't known me very long, I'm a Native American beadwork artist. I haven't done a whole lot of beadwork because of everything that went on with my sister. And I may not be able to thread this needle. This needle may be almost non-threadable. Did I get it? I got it. It's a very tiny needle. And it's the smallest of fishing wire. I don't know if you can see that. And I've made all my regalia, but I'm not finished. I got a lot more to do. I got 10 of these to do. So, yeah. The court is on a 5-minute break. It will return. Let's return to our reading of the Karen Reed documents. So, as a result, in adding to the denial of the motion, no evidentiary hearing is justifiable. The motion of the Commonwealth to exceed the trial testimony, to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach to the Commonwealth to deny Ms. Reed's ability to present her defense through her well-credentialed, methodically reliable expert witness so she can have a fair trial against the blameless charge lodged against her. I have some examples. I have some that are finished. I'll show you. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion of the Google search "Haas long to die in cold" existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp at or before 2:27:40 a.m. in the delete file state of 2:27:40 a.m. search artifact without any objection from the Commonwealth as to his qualifications or his methodology. So here, that's going to be a huge thing. Without any objection in the first trial from the Commonwealth as to his qualification or methodology. That is something that they're going to have to overcome if they want to get this guy thrown out. And for the good reason, Mr. Green has been accepted in several U.S. state courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology that proffered experts for the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 11, verified the harsh signature, value of the image file, looked at the image file, and saved it to their computers, servers, hard drives, etc., and then processed and evaluated the item filed with the appropriate tools such as Cellbrite Analyzer or the Magnet Forensic XM. While the Commonwealth witness Ian Whiffen used the only Cellbrite physical analyzer and the ArtX tool, Commonwealth witness Jessica Hyde historically used 3 or more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde. When Green and Hyde are using 4 of the same tools, this is important. Green and Hyde use 4 of the same tools. So he is an expert witness in several U.S. trials. The
prosecution did not object to him being an expert witness, and he and Hyde used 4 of the same tools. That goes to tell you a lot.
All right. Are there any matters that we need to raise and discuss out of the
Pause.
presence of the jury at this time?
There's
Pause.
one that's been brought up by the defense, Your Honor, and that is the indictment says February 6th. The
The
evidence
indictment
was-
actually says February the 11th.
That's what I thought it said too, but I was told by the defendant and I didn't have a copy.
Well, I've got a copy because I heard the same suggestion that you did, and it says on or about the 11th day of February, 2019.
Blaine Selden, he came up with it.
Just a point I brought up, and it's probably too late to address it. The murder says February 11th. The alleged act occurred on February 6th. That's when the alleged act occurred. The death of Cochran occurred on February 11th. I don't know what we can do about it or anything of that nature.
It's on or about. There's nothing to do about it.
I don't think there is anything we can, oh, we didn't have a court reporter.
Well,
I
You
thought
want a
you were
record of
down there,
that, go ahead.
Joanne. I'm sorry.
No, you didn't do anything wrong.
You didn't do anything wrong. All right, I think we can go forward. We can change the instructions and I can read them all over again, but everybody's moaning and groaning and nobody wants to hear that.
With a big sign that says, "This is Selden's fault."
It starts out a drawing, and this is custom hand drawn. This is my own pattern. Nobody else has it. There's symbolic stuff. And this is what it looks like when it's done. It is all beaded, hand beaded. This, when I have a side braid, is worn like this with my otters coming down. So that's what that looks like. I know some of y'all have never seen it. And this is my regalia pattern. This is going to all over. I have a crown that I've got to make. It's all beaded. Well, it's a headpiece, not a crown, but a lot of people call it a crown, but that's that. And I've made barrettes and things like that. So we'll get back to trial. I just wanted y'all to see because you asked. You asked.
Right.
Just for the sake of the record,
That takes,
brought
each
to- I
barrette
brought
takes
to the
about
court's
40 to
attention
50 hours.
the indictment
And I've got
says
10
that
of these
the
to do.
murder occurred on or about February 11th. I just brought to the attention of the court, the alleged act occurred on February 6th. The passing of the deceased occurred on February 11th. I don't know how that impacts anything.
I don't think it impacts anything.
My
It's on or
regalia.
about. No objection was raised. You all approved
900
the
hours.
jury charge, and we're going forward.
Thank you.
All right, are you folks ready to deliver your closing remarks?
Yes, Your Honor.
I'm just going to do this while I can. I'm going to pull it up because some people were asking earlier and I ignored their request. So I'm going to go ahead and pull up if I can find it quickly. If I can find it quickly. I'll find it and between the two sides, I'll show you.
Bring in the jury, please.
Thought it was on my desktop, but it ain't. Why are you smiling at them? That's kind of on the creepy side. Just saying.
Katie Mouse, your request has been answered, my dear.
All right, ladies and
request
gentlemen
has
of the
been
jury,
answered.
as I have alluded to, the next stage or part of this case is the final argument of counsel. You will hear from each side, and the attorneys will argue the issues and the evidence presented, giving you their own interpretation of that evidence. As I've said over and over, their remarks would not be evidence themselves, but all of these attorneys have worked very hard in presenting this case before you, and I ask you to please give them due consideration. We will follow the same order that we have established in this case. As you know, the state does have the burden of proof, and we'll go forward first. Then the defense will present their entire argument, and the state has a brief period to rebut. All right, Ms. Acord, you may proceed.
Okay.
Okay, we're going to show this real quick. I found an image. This was at a gallery, a Native American art gallery, and I went and wore my regalia. And so I want to share this with y'all while it's in my head. And then we'll get into that. This here is, I'm going to zoom in. Not the best of pictures, but the moccasins are beaded. In fact, I have them here. Come on, cooperate with me. The dress is made of 100% wool. The breastplate, which is the long thing with the white, those are real bone. All the shells on the dress are real. There's over 1,000 shells and all. And the headpiece, I'm going to scooch up. I made that. That's beaded like I'm wearing. The barrette, you can't see. It's kind of off to the side. The fan is hand beaded as well. You can't see that. What these things around me are jingles. It's a little skull can lids that are wrapped in a cone and are sewn on Native American dresses. So when they dance, they jingle. Those Native American artists, if you can see each one of these is clamped onto a ribbon. Millions of these were in this room. It was absolutely exquisite. There's the long shot. There's some more close up of me. There I am walking. The feather is not real eagle. It is illegal to have real eagle. You have to have a certain documentation in order to have it. But I just wanted y'all to see my regalia because, this is a good shot. Here's the barrette that I just showed you. I have earrings that match. This right here coming down, that fur, is an extension of my braids. That's otter. Yeah. So I handmade that. Each one of these shells is sewn on. I have a sequence on the underneath. I sew through the material, bring it up through the shell, bring it through a sequence and a bead, and come back through and hand tie off every single one. This here, this whole regalia and all of this, the only thing I didn't make was the shawl, is $900. So just so y'all can get an idea of what I'm doing here, because some people go, what are you making? So, and it's a little bit of a mental break. So now we're going to go back to the closing arguments. Are y'all ready? Da 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 dun 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 da 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 dun dun dun. Closing arguments. Here we go. Get her done.
Good afternoon, ladies and gentlemen of the jury. As you know by now, my name is Ashley Akerd. I am an assistant prosecuting attorney here in Raleigh County. I've been presenting this case to you with Tom Truman, who is our current prosecuting attorney. We're here in the matter of State of West Virginia versus Natalie Page Cochran. And if you all will bear with me, I will have to do some reading as we go. There's a lot of ground to cover here. So the first thing I want to do is thank you for being here. Just very briefly, I know everyone does this, but this has been a long couple of weeks and we've had a lot of evidence come in this case. So just thank you all for sitting through it with us. Thank you for being here and thank you for
You didn't have a choice. We didn't have a choice, my dear. No choice was made
Now, at
by
this point,
us.
you all know why we're here and what we've been doing for the last few weeks. My job today is to prove to you beyond a reasonable doubt that this woman, Natalie Cochran, feloniously, willfully, maliciously, deliberately, and with premeditation killed her husband, Michael Cochran.
I don't
This
know if they
entire
got there,
tragedy
y'all.
can be summarized into 3 different blocks of time. September 29th of 2017 through August 26th of 2018.
Y'all go vote.
September 1st of 2018 through January 30th of 2019, and January 30th of 2019 through February 6th of 2019, the week that Michael falls ill for the last time. Now, Michael Cochran was 38 years old at the time that he died. He was
Oh,
a
wow, that's
father,
young.
a husband, and a son.
And a brother and a
He was a very fit and healthy man. He cared a lot about what he looked like and a lot about what people thought of him. He lived and worked here in Raleigh County. As you've heard, he worked in technology. He also worked with Workforce West Virginia. Ultimately, he was a minority partner in the business Tactical Solutions Group, in which his wife, Natalie Cochran, was the 51% majority owner. And we'll just briefly talk about TSG. We don't have to get too far into it, but I feel like we need to cover that ground again. TSG is represented through its website to be a leading supplier to the Department of Defense, national security agencies, federal civilian agencies, prime contractors, and nonprofits worldwide. And we've heard a lot about how the business ended up not being super legitimate. In fact, it wasn't at all. But it originally was set up that way. They had filed with the Secretary of State. It had a business license, and it actually was registered with the federal government to bid on government contracts and to be awarded those contracts. It was held out to be a woman-owned small business, which gave it priority in getting contracts. But a business like this required one thing: startup capital. There was 2 ways that the business obtained startup capital, and that's the money that's needed to get it off the ground and get things running in general. The first way was through investors. And what would happen was Natalie would go to her friends, her family, people in the community, ask them to invest in this company. They were promised a return on their investments when contracts were ultimately fulfilled. They'd get more money back than what they put in. And sometimes, when the money would come back, she would ask them to invest again so they could get an even higher return on their original investment. So some of these people were putting money into this company over and over and over again and seeing very little payout, if any. The other way that TSG gained startup capital was through loans. She would apply for small business quick capital loans. And what that means is these were rescue loans. These were for companies that were in trouble. They would have a very high interest rate, and you would have to pay back on them daily. And now I'm not saying that Michael didn't know about investors and didn't know about loans. He knew people were investing. He knew there were loans. But they weren't what he thought they were. Some of the loans, he was told, were SBA grants. What's so special about a grant is that you don't have to pay the money back. That money is given to you for a specific purpose. Otherwise, he thought they were getting government bonds. Specifically, Natalie held out the loan companies to be factoring companies. And what factoring companies do is they buy all of these accounts receivable that you have, and they'll pay you for a portion of them, and then they'll collect the money later. So that's what she told him was going on. So what happens next is about August 26th of 2018, Michael really discovers the extent of family investors and investments. You heard that he got into Natalie's phone at one point and read her messages, and that's how he found out. He was completely unaware of the lucrative returns and profits that were being promised to people. He was quoted as saying she was giving away our money. On August 27th of 2018, Natalie sent a message to a few family members, which we've put in evidence and you all have seen. Hey guys, after the contracts that are out pay off, I will have to stop subcontracting. I wasn't as transparent with Michael as I should have been. After this, Michael and Natalie made rounds to family members, trying to pay some checks, trying to pay some people back. But ultimately, Michael realizes that the amount of money that they owed people is a lot more than he knew. So now he wants to be more involved and understand how everything works. On August 27th of 2018, Natalie sends Michael this message, this series of messages. 3.45 million should post tonight at midnight. 300,000 should post Wednesday. 1.25 million on Thursday. 724,000 Monday of next week, and 2.56 million next Friday. You've heard that Michael was spending money. This is why. This is why he was so charitable. You heard that he donated a weight room to a middle school. He bought uniforms for youth sports. He bought a house for a youth pastor who had nowhere else to go, and later rented that house out to Chris Davis's recently widowed aunt. He was trying to give to people. And he'd been led to believe that this legitimate business was thriving and all of this money was due to them. She set a prize date, though, when she did this. All their hard work was going to start paying off at midnight.
That doesn't
So what
make
did this
sense.
ultimately do? It created a big problem. It created a bunch of promises that Natalie couldn't fulfill. And those promises totaled, at this time, $247,499,232.
How can you be promised that much money unless you're Trump or someone like
So in
him?
our next time frame, Natalie starts to claim that the government is conducting an audit of TSG. And she uses this as a reason that they can't pay money to investors, a reason they can't get contracts, they can't get paid on outstanding contracts, and the reason that they're not seeing any returns. So she solicits 2 more investors. One of those was Chris Davis, who told you about that. She obtains 3 more rescue loans. On October 25th, Natalie tells Michael the audit is complete. We're going to have our money October 29th. So what happens right around that time? October 31st, Michael goes to the hospital. He's expecting $248 million on October 29th. The money isn't produced. On October 31st, he's sick. He goes to the hospital and he gets discharged, but he's not well. He's not better. And the defense would have you believe that Michael was incredibly sick all the time, that he left the hospital, went back to the hospital because he got sick all over again. No, he was sick one time. He just didn't get better. It happens. It happens all the time, all over the world. When Michael went back to the hospital on November 2nd, Natalie reported that he had had a seizure. That was never confirmed. You heard experts testify that the seizure activity in the records was reported by the defendant. Everyone else who testified said they had never seen him have a seizure. At that time, he had his friend Chris Davis take him to the hospital because he wanted to be treated. Nobody wants to feel the way that Michael felt.
Fair enough.
But other than this, he was healthy. You would think that he was sick, though, because he was stressed out of his mind, because he was waiting for $248 million that had been promised to him that he hasn't seen.
That's enough to
But
make
it still
me
isn't
sick.
coming. And there's a whole lot happening during this time.
I'd be
A
puking.
phrase that we've been throwing around a lot on our team is that Natalie Cochran involved everyone and included no one. So on December
way to say it.
4th, BB&T is closing the Cochran's accounts. Michael goes to BB&T, and you've heard about that. He is irate. In fact, his friend Chris Davis is called to come down to the bank because Michael is causing such a scene that there is fear the police are going to be called. He's angry because he thinks these accounts closing is why he's not seeing any money. So ask yourselves, if Michael was involved in a felony level financial crime involving hundreds of thousands, at this point, hundreds of millions of dollars, why would he go cause a scene at a bank and potentially get the police called on him.
That's a good point.
He didn't know what was going on. And this is where Natalie gets lucky for the first time. On December 6th, the government's already partially shut down and is only funding certain departments. I'm sure we all remember the government shutdown because it was a really big deal and a lot of people had a really hard time because of it. On December 22nd, the entire federal government shuts down. So we've gone from an audit to a federal government shutdown, buying her more and more time. And the shutdown becomes the reason that they're not getting paid. Now, Natalie has told Michael and all the investors that the money's frozen because of an audit. Now, the government's shut down. Next, she tells people she has cancer, chronic lymphocytic leukemia, which we talked about that a little. We've never found anything that indicates that that was real either. She now has to deliver. So she tells Michael and she tells the investors, on February 1st, the federal funds will be released because the shutdown has ended. So why does the money come in on February 1st? It's January 30th of 2019, and we have entered the week of Michael's illness and ultimate death. So here is where she gets sloppy. Her motive to kill him becomes very clear because he is very quickly catching on. It becomes very obvious who's been running the company, that Michael has no idea about the Ponzi scheme. And more importantly, we're seeing that Michael's about to discover the truth of everything that's been going on. So she has two choices. She can come clean, or she can go into self-preservation, which requires that she take him out of the equation and make sure he never finds out what was happening.
And that's what she did.
January 31st of 2019. Natalie says, I'm on the phone with Bank of America. Michael says, are we 1,000%? Yes, she's sending them with tracking. Money is supposed to hit tomorrow. February 1st of 2019, the fund release date told to investors and told to Michael, no funds hit any accounts. This was a Friday. So Michael knows at this point, Monday is the next day he can do anything. So on Monday, money isn't in there. More excuses.
Yep.
Michael is getting increasingly concerned. Later that same day, she says that she spoke with the wire department. All of this money
Oh,
is about
yeah.
to
I would be flipping a lot of things over.
4.8 million in the morning, 23.8 tomorrow sometime. Michael says, shit, can't do anything today. Michael was just like the rest of us, as you can see. Doesn't make any sense. I certainly don't think it makes any sense, ladies and gentlemen. And that's because nothing he was told was true. So let's get into Michael's murder. February 4th of 2019, Natalie sends Michael a text message. I'm at the pharmacy. Need anything? Now, if you'll recall from Dr. Halsey's testimony yesterday, on February 4th of 2019, Natalie was picking up her prescription for Xanax, which Dr. Halsey also testified is a benzodiazepine. Michael is allergic to benzodiazepines, as you've all heard.
And his doctor knew that, so he would not have prescribed that to him.
On February 5th of 2019, Natalie goes to Access Health and sees Dr. Halsey with flu-like symptoms. She says she's vomiting. She reports a fever. She's negative for the flu and strep. She got a steroid shot and labs that day. Now you'll note that this is the doctor who, she said, put her on such a high dose of steroids. That was her words, high dose of steroids.
What's a high dose?
As we'll later see her tell Jennifer Davis.
How much was
But
the dose?
he didn't give her a prescription for insulin. And you heard his testimony yesterday that he didn't instruct her to get insulin. On this day, she also requested methylprednisolone from Stephanie Hamilton. Now, we all know that is Solumedrol. And if you'll recall, a vial of methylprednisolone was later recovered from the Cochran residence when the search warrant was executed. FBI analysis told us that that bottle had never been used. The same day, Natalie reaches out to Albatross Air, the Kearns family, and schedules a flight for her and Mike to take the following day to Lynchburg, Virginia. We've heard a lot of talk about that flight. You heard from Court Nexon, who is a former Bank of America employee. And he told you that the Cochran's account was never funded. There was never money in their Bank of America account. Mike couldn't understand why. So sure, they were going on this trip to fill out signature cards and things like that. But they were also going to find out why contract funds weren't posting to this account, why all of these wire transfers we've heard of were not coming through. And if they went on that trip, it would have changed everything.
That would have been devastating.
So on February 6th of 2019, the last day that anyone sees Michael Cochran conscious, 6:34 a.m., Natalie Cochran texts Chris Davis. She tells him she can't go to Lynchburg because she has a fever of 103 degrees. Now, you'll recall she asked Stephanie Hamilton to bring a thermometer over because she apparently didn't have one. 6:35 a.m., Natalie texts Josh Kearns at Albatross.
If you
Air,
have a fever of
cancels the flight to
103,
Lynchburg
you
because
wouldn't
she
be
has
that.
the flu. Mike tells Natalie to tell Court Nexon and
Anybody ever had a fever of 103 or higher? I have. I had scarlet fever and meningitis, and my fever went as high as 105.6. 103, you would be freaking hospitalized or very close to it.
his boss that they won't be there today because she's sick and they'll come tomorrow. But if they still need him to come today, Mike will go and he'll take his friend Chris Davis with him. They'll come back and get her signature card notarized. Mike very much wanted to take this trip. 6:37 a.m. Mike tells Natalie to get Court Nexon to wire them $5,000 to $10,000 from their account. The account that is still sitting empty at Bank of America.
Dang.
Natalie
y'all.
tells Mike she's already canceled the flight and he tells her to reschedule it for the next day. And this, ladies and gentlemen, is the text canceling the flight to Lynchburg, wherein Natalie says that she's been up all night with the flu, which we all know she was never diagnosed with. Later on February 6th, she sends this text message to Michael. I'm in the doctor's office getting swabbed again, getting a Prometh shot, getting you and I both meds. Now, Mike is currently out and about in town. He goes and gets some Starbucks at 8:37 in the morning. Natalie arrives at Access Health at 8:10. She says she's getting them both meds. Now, you heard Dr. Halsey testify yesterday. He didn't see Michael that day, and he did not prescribe anything for Michael that day. In fact, the only medications that Natalie was prescribed that day were promethazine tablets. Promethazine, which Michael is critically allergic to. So what did she tell him that she got him? And isn't it interesting that Natalie Cochran runs straight to the doctor at the first sign of trouble? Frequently. But let Michael Cochran lay on the couch for 6 hours, unconscious. And let's ask ourselves how Michael was feeling around this time. Well, you remember Jason Bowen telling you he, quote, felt like he was being poisoned.
He was.
She later texts Jennifer Davis, we are both sick. So they put me on such high-dose steroids, I have to start taking small insulin shots. Gonna have to order a vial.
Okay, that is not how that goes. I have been on prednisone.
Again, there's no records that support any of this. There's nothing that indicates.
Just so y'all understand who are not in the medical field. This is bullshit. There's no other word for it. I was on at one point 90 milligrams of prednisone. That is sky high. That can cause drug-induced psychosis, and it did. But not everybody develops a diabetic or low or high blood sugar from prednisone or steroids. Can it cause? Yes. But you are not going to sit there and a doctor is not going to prescribe you prednisone and insulin at the same time. They don't do that. That is not, now, the only way that could happen is example, I've been on prednisone for over 15 years. Okay. I'm not on it regularly now. I refuse to do it because it puts a lot of weight on you. And it also damages your connective tissues and whatnot. But if I'm on a dose pack, which is what she was probably given, which you take 5, 4, 3, 2, 1 a day, 5 a day, 1 a day, 5 a day, 4 for day 3. You just kind of titrate down. And if my camera blinks, don't panic. Okay. So if she was put on a dose pack, they're not going to sit there and give her insulin. They're not. It's BS. Any of my nurses out there or doctors disagree with me? They're not going to sit there and give you an open-ended prescription for insulin when you start taking a prednisone until you are having the complication. And I want to know how much prednisone was she taking, because I guarantee it that is the biggest bunch of BS I've ever heard in my life.
Is that she needed insulin for any reason at all.
No, she didn't.
And
there's no
if
reason.
Mike was really keeping insulin in the house for his bodybuilding that everyone keeps talking about, why couldn't she use that?
Exactly. And why would you use
she need to
insulin
get
for
it somewhere
bodybuilding?
else? And I'll also add, the last text between Michael and Natalie Cochran is at 8:51 a.m. on February 6th. Following that was a 15-second call at 8:52 a.m. And this is the last time we know of that they spoke with each other.
Probably didn't know.
Later on, as we all know, Jennifer Davis offers up a vial of insulin because she's a good friend. She's worried about Natalie. She thinks her friend has cancer.
Okay, and
she thinks that she's dying.
And here's the other thing. It is illegal for her friend to have done that. And it is illegal for her to request it. And everything there is gone wrong. And I'm surprised they did not go after that friend. It's not a controlled substance like hydrocodone, but still.
But she offers up her own son's vial of insulin.
That's insane. Why would you do that?
Natalie sent another text to Jennifer Davis. Mike's sick today too.
Got another vial?
He didn't get anything prescribed for him. He didn't go to the doctor. All that we've heard is that he laid on the couch for a couple hours.
Hmm.
Chris Davis shows up a little while later, and as we all know, drops off a bag, which he testified that he never looked in. His wife, Jennifer, told us exactly what was in the bag. Some Propel, a Diet Coke that Natalie asked for, and a brand new unopened vial of Humalog insulin.
And do you know what there
Jennifer
are
says,
different
"You're
brands
welcome,
and
but that's
different
nothing.
strengths.
I sure wish I could do more."
How would she know how much to use? How would she know how much insulin she needed to use? Did she know the math and numbers? And why did she not get it from her physician? This is, and she's, I just want to smack her. I'm just going to say it.
for you. And Natalie's words are, "That was perfect." And I bet it was.
I bet that
Another
friend
message
really
she sent
feels
Jennifer
bad now,
Davis.
aiding and abetting a
Mike
murder.
was so mad this AM about not being able to go today. He had to take 2 of my blood pressure pills.
What? Why is he taking? Wait a minute. Wait. So now yeah. Analog is very fast acting, very scary. Yeah. Doesn't matter what she was. It still needs to be prescribed from a physician. And even if she did understand and know what to draw for diabetic, the chances of her getting a diabetic attack from actual prednisone at the levels that she was probably prescribed and not for sure, you know what I'm saying? I gotta fix that. It's driving me crazy. I'll fix it when I'm done. She's definitely on a crazy road. She's on the crazy road. Because now you go from insulin to this.
Now, the last documented
Blood
communications
pressure medicine.
from Mike's phone.
Why would you give your husband your blood pressure medicine? Unless you're both on the same thing, then you would give him his. This doesn't make sense, y'all.
11:15 a.m. John Hamilton told you he called and didn't get Mike. He leaves a voicemail message. 1:39 p.m., which you heard testimony today, we believe Michael was unconscious at that time. A text goes from Michael's phone to Matt McCormick. "Should be good, buddy. I'm available all weekend too. Whatever works best."
This is
12:29
amazing.
on February 6th of
stupid.
2019. Natalie Cochran takes this photo of her husband Michael laying in their kitchen floor. Now, ladies and gentlemen, I don't know about you, but if my
I
husband
would be on the phone with
had a
911.
serious medical event and was lying unconscious in my kitchen floor, I wouldn't be taking pictures of him. I'd
No.
be getting help. The first person she sends it to is her sister Penny, who testified that her reaction was, "Well, what does she want me to do about it?" And I think we all know the answer to that question.
She wanted to use an alibi.
Next, she reaches out to John Hamilton, who you heard testify a few days ago. She tells him, "Mike is sick like last time. Last time when he asked to be taken to the hospital. Last time when he wasn't left unconscious in his kitchen floor." John heads that way, and Natalie then calls her private contractors, Jason Bowen and Jonathan Miller, to come to the residence and help. You heard Jason testify that they were at Lowe's at the time. The story he was given was that Michael threw up in the sink and then used the kitchen cabinets to lower himself to the floor. Jason and Jonathan arrive and they move Michael to the couch, and Natalie begins reading them vital signs that they can't see. That includes his blood sugar. Why would you check the blood sugar of someone who doesn't have diabetes or any known
Exactly.
problems with regulating his blood sugar?
Exactly.
Ladies
Well-
and gentlemen, I'll posit to you that if he were just sleeping it off like she wanted,
I will say, I have been on a call where someone had crumped, what I call crumping, where they just went down and nobody understands why. And I'll ask the spouse or the family person or whoever's there, are they diabetic? Well, no, but you know, you never know when someone you know, there's always a first for a diabetic, right? You go around life, you're fine, you're not diabetic. Then all of a sudden you have an episode if it's not caught at the doctor's office early. And come on, when you have an episode, you don't know until you do. So that's not an unreasonable question for someone to ask. But for her to know, to have a blood testing glucose test machine in her home when she's not a diabetic, he's not a diagnosed diabetic. So why would you have that in your home unless you were or in a med kit like me? I'm not diabetic,
but I am a first responder, so I do have a kit. I do have glucose tablets and everything in my kit. So that's fine. But for her, that is creepy, freaking weird. Just saying, y'all. Not normal. No bueno.
Wanted him to do, he would have felt that finger stick. I've
Eh,
had 100 finger sticks. I know what they feel like.
that's
not gonna
exactly
sleep with it.
right. Well, it depends on how bad the diabetic.
At that point, she reports that his blood glucose is 145, and this is at 106.
I have to say, this woman is getting on my nerves. It depends on how good the stick is, and it also depends on how far gone you are. If you are at a state to the point that you are going unconscious, you may not feel a finger stick. Just saying. Not all of them hurt like hell.
6 p.m. John Hamilton shows up shortly after that, maybe 20 minutes after she contacted him the first time. He told you that Michael was already laying on the couch when he got there. He immediately asks, how are we going to get Michael to the hospital? Natalie's response is to let him sleep it off. She now tells him that Michael was sick and had a seizure. John noted that he had never seen Michael have a seizure. John then contacts his wife, Stephanie.
If you've never
who's a
had one
physician
and you
assistant, as
have
all
one,
heard.
you're calling 911.
He asks her to come over and, quote, get her to take him to the hospital. So Stephanie arrives a little later and takes Michael's temperature. She made it a point not to startle him and even warned him that she was going to be taking his temperature. But he doesn't wake up. Stephanie also tells Natalie that Michael needs to be evaluated. Natalie again declines and says Michael wouldn't want to wake up in a hospital. Stephanie even gave her an out. She said, he can blame me. Also, at some point during the day, Natalie and Mike's kids come home from school, and Natalie's sister, Penny Lowry, arrives. Penny told you that Michael had an accident, and she held a blanket up while Natalie changed him into dry clothing that was retrieved by Natalie and Michael's daughter, Nicole. Thomas Treadway shows up later. When asked if he believed Michael needed to go to the hospital, he told you he's not a medical professional. Natalie's text messages indicate otherwise. They indicate that he believed Michael was getting worse and that he needed to be checked out. So you decide. At 4:34 p.m., Natalie reports that Michael's blood glucose is 115.
Normal.
She tells others that Stephanie Hamilton took that reading, but Stephanie
Normal.
Hamilton took the stand and told you that was not true. Lastly, Chris Davis, Michael's best friend by all accounts, arrives at the residence. He told you how he ran his thumb up the sole of Michael's foot to see if he could startle him awake. He told you that he tried a sternal rub. Nothing.
Y'all, sternal rubs are
His
painful.
words to you were, he is going to the hospital, and I'm going to take him.
And the finger thumb
At
rub.
that point, he
Okay, I want to explain that. This is the sole of your foot, and you do it this way, you're not going to do anything. But if you take your nail and you dig it in and you do this, you're going to react. Sternum rubs, oh, they're painful. Sometimes you can even get bruising from a sternum rub.
He and Thomas Treadway load Michael into the back of the Cochran's car, where Natalie rides with him as Chris drives him from 4H Lake Road to Raleigh General Hospital. When Michael arrives at Raleigh General Hospital, his blood glucose was 21.
Wow!
That's a far cry from 145 and 115.
145 is slightly high, but it depends on when
Seemingly,
he
plummeted
ate.
out of nowhere.
That also depends on when he
You
last
heard from
ate.
Dr. Uribe and Dr. Krieger. The only reasonable explanation is exogenous insulin administration. And ladies and gentlemen, the defense has posited to you that if Natalie Cochran injected Michael with insulin, whoops, dropped the needle. Here's the good news, I brought it back up. He would have felt it.
And they're painful.
I don't care what you say.
This is an insulin needle.
If it's done right, it's painful and it's
Yeah,
meant
I'm
to be
just
startling.
a
It's
restriction. This is bringing outside the evidence before the jury.
This is a demonstrative exhibit, Your Honor.
Overall, it is a demonstrative exhibit used in closing arguments. Members of the jury, you are the judges of the evidence. This is a demonstrative exhibit. I want you to rely upon your recollections and your memories of what the evidence has been in making your decision. There's a certain rough and tumble that we allow and some latitude in terms
Oh, I
of
like the way you said
closing,
that. Rough and
remarks.
tumble.
I'm going to, as I say, overrule the objection and permit counsel to proceed.
Thank you, Your Honor. Ladies and gentlemen, I want you to see the size of an insulin needle.
Yeah, I have some here.
That needle I just showed you holds 30 units of the kind of insulin that Gavin Davis was prescribed and that was received by Natalie Cochran from Jennifer Davis. Dr. Krieger told you how small a unit of insulin is, and you can see it for yourself. Extremely small.
Yeah.
I would also say we made it pretty clear yesterday that the defense experts did not have the full picture. They had incorrect and incomplete information, so how could they make an informed opinion? And when Michael arrived at Raleigh General, as I said, his blood glucose was 21.
That
He
is
was
like
immediately
death.
intubated. And he never woke up.
Yep.
February 7th through 11th of 2019.
How
Michael
he
was
was
transferred to Charleston Area Medical Center.
how was he even alive at that point is beyond me. I know people do, but my father was a brittle diabetic. He was so bad. He had an insulin pump all the time on his person. It had a needle that went into his skin and it was constantly monitoring him. And he'd wake up in the middle of the night seizing from excessively low. And that was like 27, 25. So 20, and that, I mean, he was life flighted when that would happen. So that there is insane.
CAMC.
Oh yeah, they apply
His MRI
pressure.
there, as you've heard, showed diffuse hypoglycemic encephalopathy, brain swelling caused by low blood sugar. February 10th of 2019, Michael is transferred to hospice care at his wife's request. He spends 5 hours there before he dies. Now, you'll recall during Thomas Treadway's testimony that he advised Natalie needed to remember that she took his vitals that day and that she needed to make a timeline of the events leading up to Michael's death. Why? Here's some of the different stories she told. Michael was sick in the sink and fell. Michael was sick in the sink and lowered himself to the floor. I heard him hit his head, and when I went in there, he had fallen. She also said he was vomiting in the sink, had a seizure. And
Where's
then
the
hit his
vomit?
head.
I would have swabbed that
And
sink
that's
for
just a few
vomit.
of the stories we heard.
I would have been swabbing.
Now, a search warrant of the Cochran residence was executed on June 25th of 2019.
Did they find any of his DNA in the sink?
And I would note that
In the drain?
TSG has continued business up to this point, even getting additional investors after Michael's death, including the Hamiltons. During this time frame, Natalie also pled guilty to the charges that you heard about in federal court, the wire fraud and unlawful monetary transactions. During the execution of that search warrant, a lot of things were found and taken from the Cochran residence. Of note
good.
for us was the unopened methylprednisolone vial and the insulin that she kept in her refrigerator. Now, if you remember when Lieutenant Bledsoe testified, he told you that when he reviewed the property receipt from the search warrant with Natalie Cochran, she flipped through it and immediately went to the insulin. And she said, "I keep that for my neighbor's son who has diabetes."
Nope.
Ladies and gentlemen, as I stated previously, the elements of first-degree murder.
How often is your neighbor's son here in your home? Mhm. And how often has he needed insulin while he's here? Mhm. Does his mother not carry glucose tablets? And does she not live close enough that they cannot go home and administer the insulin themselves? See, there's a whole lot of questions there. Now, if I am at my parents' house out of town and they have a vial of insulin that I keep there because I'm out in the country and away from everybody and their brother, then that's more understandable. But this, it don't compute.
Are a felonious, willful, malicious,
I would for my dad.
deliberate, and premeditated killing. Felonious is simple. Murder is a felony, and it's against the laws of the state of West Virginia. Willful or deliberate would mean that someone took an overt action in furtherance of an anticipated result. She injected Michael with insulin. Dr. Krieger and Dr. Uribe testified that there was no alternative, reasonable explanation for Michael's blood sugar to be 21 other than outside insulin administration.
Yep.
She also let him lay on the couch for 6 hours. She brought in all this help over and over just to refuse it. Malicious, showing or having a desire to cause harm. Natalie was a diabetic counselor and a pharmacist.
Oh.
She knew that injecting insulin into a non-diabetic would cause harm.
At least at that level.
She chose over and over, after repeated pleas
I didn't
from
realize she
friends
was a
and loved
diabetic
ones
counselor. Sorry.
to leave Michael on the couch, laying in his own urine.
Oh,
She also
man.
showed a complete indifference for human life when she continued to work on contracts and make plans for bingo while her husband lay dying in the hospital. Premeditation. She obtained the murder weapon in advance from Jennifer Davis. And poor Jennifer had no idea what she was getting herself into when she did that. She had a clear motive, and you saw that leading up to this date, Michael was about to find out what she was doing to people. Do we know what he was going to do with that information?
nope.
We never will, because he won't have the chance to tell us. Michael was killed because following the actions of the defendant, he was admitted to multiple hospitals and ultimately passed away at hospice. Well, there's a couple of defense theories that I just want to go ahead and debunk while we're here.
Yes, please do.
The first being, Natalie was a pharmacist and could have gotten undetectable drugs to kill Michael. Those were defense counsel's words. She did, just not as a pharmacist. She hadn't worked in pharmacy for 2 years at that point.
Ah, that's interesting to
Insulin
know.
can be bought over the counter. Stephanie Hamilton debunked this one. She testified that Humalog, the kind of insulin that was used to kill Michael, cannot be bought over the counter
Nope.
and has to be obtained via a prescription, which neither Natalie nor Michael had. Michael was a, quote, ticking time bomb. Michael's previous illnesses can only be verified by Natalie. No one else ever saw him have a seizure. Sure, he went to the hospital, but they were never actually able to verify that seizure activity occurred, only that it was reported at home. By her own words, Mike was doing the best he had ever done in his life. You heard testimony that he forgot where he parked his car. Ladies and gentlemen, I don't know about you, but I forget where I park my car all the time. It's very common. He participated in tough man competitions and Jeep pulling competitions. That doesn't sound like a sick man to me. You also heard that Michael was on steroids. Chris Davis testified that Natalie told him that she was in charge of all of his supplements and vitamins. No steroids were recovered from the Cochran residence when the search warrant was executed. The
That's
Mexican
an
supplement that we've
interesting
heard
little
about turned out to be a
point.
female fertility drug that came from Florida. You know who had communication with that company? Natalie Cochran. Ladies and gentlemen, in closing, Natalie Cochran had the means, knowledge, and opportunity to commit this crime. She dosed Michael Cochran with insulin that he was not prescribed and that he did not need. You may not have done the math, but I have. Next Thursday will make 6 years to the day since she injected Michael Cochran with insulin in his home. 5 days after that,
He
will
was
be
gone.
6 years since Michael Cochran left this earth. 6 years since 2 children lost their father. 6 years since this woman, Donna Bolt, and this man, Ed Bolt, lost their son. 6 years since they were able to see him for the last time. Michael and the people that loved him deserve to have the most thorough investigation that we could conduct. And we've done that. We've done everything we could to show you what really happened to Michael. These people have waited long enough for justice. Michael
for you,
has
honey.
waited long enough for justice. Ladies and gentlemen, I'm asking you at this time to deliver that justice and to find his wife, Natalie Cochran, guilty of the first-degree murder of Michael Cochran. Thank you.
Good job.
Mr. Victor.
May it please the court, counsel for the state, ladies and
Oh,
gentlemen
here
of
comes
the jury.
Mr. Penguin. Mr. Penguin, how are you?
About 2 weeks ago, when I stood in front of you, I told you a couple of things about this case. And one was that Natalie Cochran was guilty of financial fraud, of financial shenanigans, and that she was indeed guilty without any reservation. But we're not here today to retry that case. And everything that the state is telling you about Natalie Cochran, yes, let's shed some light.
That was me, sorry.
Thank you, Judge. Everything that we've heard about this financial case from Natalie's standpoint is true. She was convicted. She was a participant in the Ponzi scheme. But we're not here to judge her yet again on the financial crimes. We are here to judge her on the murder of her husband. And the state cannot prove first-degree murder against her beyond a reasonable doubt. The state cannot prove 3 things. The case cannot prove what, the case cannot prove how, and the state cannot prove why. First question, what was Michael Cochran killed by, or what killed him? And you've heard the evidence over the last 2 weeks that we don't know. The experts that the state brought testified to what they themselves admitted, a definite maybe. Maybe it was the insulin shot, and maybe not. The experts that the state brought testified to, we cannot determine the objective factors, the objective anatomical findings, and tangible demonstrative evidence what killed him. They don't know. The state's expert, Dr. Krieger, said, well, the
Money, money,
hypoglycemia
money,
due
money.
to the
Go around,
insulin
go
administration is a strong possibility, but it's just a possibility. Why don't we know what killed Michael Cochran? Well, because they did not perform the autopsy. And by the time all these experts got the evidence, Michael Cochran's body was so decomposed that it is impossible medically to determine what killed him. And you heard the testimony of two defense experts. And you also heard the testimony of my compatriot, Dr. Piotr Kubitschek, who is the medical examiner who performs autopsies on a daily basis and who is, I would submit to you, a little bit like Matlock. He is the medical detective trying to detect what is the crime that led to the death of that particular individual. All these experts said the same thing. The cause of Michael's death is undetermined. We don't know. The state cannot answer or prove beyond a reasonable doubt the how. How did that happen? How did this murder happen? I'm not particularly good with syringes, but, well, we'll come to that. The state wants you to believe that there was an insulin shot injected into Michael that killed him. But then the state also tells you that it could have been more than one insulin shot, because when Michael arrived at the hospital, his sugar level was 21. The experts told you that it's impossible to have that type of sugar level without being pretty much continuously shot with insulin.
Not true.
So how did that happen? Well, let's follow the state's theory.
Look what I have, y'all. No, I'm not diabetic. That's right there. That's a half a cc, half a milliliter right there. If you fill this whole thing up with insulin for someone who's never had insulin or does not use it, and you inject them, fill it up and inject them again, I want to know how much was in that vial. You can know how much he got by what's left in the vial. But this is an insulin needle. Most people would get about right to here, maybe right to there. If you're extreme diabetic, well, you may fill the whole thing up. But y'all, I'm a first responder. That's why I have it. So anybody jumping down my butt for it, don't worry, I'm good. I have a med bag that you would
cold-blooded
love.
killer
Paramedics
is
love.
planning a murder of her husband,
Right.
with the insulin shot. In that regard, she is calling her friend, Miss Davis, asking for insulin on the day of the injection of that insulin. I might just as well have asked for a gun. Might just as well have asked for a murder weapon.
She did.
Jennifer, I'm trying to kill my husband later today. I need the insulin, and I'm trying to kill him with insulin. I need you to bring me some insulin. Is that the action of a planning cold-blooded killer?
Yeah.
She would get that insulin ahead of time. not on the day
if
of
she's
the murder,
panicked.
and involved two witnesses against her right there and then, who came here to court.
Guys, I'm playing devil's advocate, of course, and I won't tell you what I think until we get to the bitter end. But I will say this. If she was not planning on unaliving him that day, but realized, oh crap, I got to do this now, and I need to incapacitate him, insulin's a way to do it. You give somebody enough insulin that don't need it, they're going to become quite incapacitated. And I think that's what she did. And do you know what? If that's what happened, she was successful. But she would know how to handle all that because she is an insulin. She's a pharmaceutical who deals with diabetes.
Court as predicted and testified that that was and they gave her the insulin. And then
And she hadn't worked in the pharmaceutical
How
for a
on
couple of
earth
years.
did she inject that insulin into Michael? Well, let's look at these facts. Did she approach Michael from the front when he was facing her in the kitchen? And if she had the insulin injection in her hand, wouldn't he have the time to react
Not
and
necessarily.
say, what is going on? Let's assume for a moment. Then she approaches him from the back when he's standing in the kitchen, and she jabs him either in his back or his rear end. Well, she has to have a couple of seconds to inject this insulin in him. Basic human reaction would be
Dude,
to turn around.
it doesn't take but 1 second. That's it. Too late. Once it's injected, too late. I don't know. He may have thought she was giving him vitamin B12 shots. A lot of people get
And face the
vitamin
assailant,
B12 shots.
be it his wife or be it some cold-blooded killer, a stranger. She wouldn't even have time to plunge in insulin into his body without him turning around. And he's an athlete. He's this huge guy. And here is his 5'1" or 5'2" wife.
I know
who's
some very
injecting
huge
him
guys
with
who are terrified
insulin,
of
and he
needles.
doesn't react. That's why I said it didn't happen in silence. My first reaction would be, what on earth are you doing, woman? Or whatever he calls her. What are you doing? And then somehow he drops there in a fetal position in the kitchen. No, that didn't happen that way. Of course it didn't.
It takes time, but yeah.
So now you heard the evidence from at least 4 or 5 witnesses.
Actually, I'm starting to remember a case many years ago, and I can't put my finger on it. A woman put insulin into her husband's coffee. A lot of insulin, and dumped it into his coffee, and he drank it that morning and ended up in a coma and died.
Type of insulin acts in a delayed way.
You know,
minutes, 15
vitamin B
minutes,
is
up to
a
half
shot
an
that
hour.
he would probably have been comfortable
If I'm
taking.
jabbed, even by my dearest wife or by somebody else with a substance, and if she is silent, that's one thing. And if she tells me, this is for you, you son of a gun, I hate your guts, whatnot, here it is, I'm killing you, I would have 10 to 15 minutes, maybe to 20 minutes, to 30 minutes to call 911, to run to the hospital. I told you it was 7 miles from the hospital. He would have been in the, I know it's February, but he would have been in that hospital sooner than you can say hello, sooner than you can slap a tick. He would have
Slap
been in that
a
hospital
what?
asking for help.
What did he say? Slap a. Okay. Did he say what I think he said?
an immediate sugar reaction or sugar
I'm going to go
injection.
back and see if the
Where-
captioning
But he
catches
would
it.
have been in that hospital sooner than you can say hello, sooner than you can slap a tick.
Oh,
He would have been in that hospital asking for help, an immediate sugar reaction or sugar injection to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't have just dropped down on the floor.
okay.
So how
I
did
got
it
it. I got it.
happen?
I got it.
Well,
I
the
got it.
state then gives you an
I got it. I
alternative,
got a different
because now they're
captioning up.
changing their theory. That may
I got a different captioning. I want to see what it says.
I mean, I know it's February, but he would have been in that hospital sooner than you can say hello, sooner than you can slap a tick. He would have been in that hospital asking for help, an immediate sugar reaction or
That's
sugar injection
still bad.
to bring that insulin level to some normalcy. He wouldn't have taken it in silence. He wouldn't
My
have just dropped
captioning
down
said
on
the
the-
D
on the
word.
floor.
I don't
So
know what he
how
meant.
did it happen? Well, the state then gives you an
Tick,
alternative,
stick.
because now they're changing their theory. That may have happened in bed. Ah, that's a novel idea. Inject him in bed, he would not have reacted? Of course he would have reacted. He would have gotten up and he would have done the same thing. He would have taken himself to the hospital. He would have called 911. He would have probably not been particularly happy with Natalie, but that doesn't mean anything. He could have saved himself.
Guys, all right. I'm going to argue with this guy because I will say this. I have known people. I have had shots. I used to have to give myself shots every week, 2 different kinds. And one was with a small needle like that, and the other one was a large needle. And I will tell you that if given in the right location, it wouldn't wake me up because I didn't feel it. Some shots you don't feel like other shots do. So I'm kind of on the fence about this thing with him. What are your thoughts? But I will say, if he thought it was a vitamin B12 shot that she was pulling for him, they come in little vials and you can draw your own shots.
Then the state changes the theory again. That may have happened upstairs, or it may have happened on the couch, or he's injected on a couch. Well then, okay, so he doesn't get up. So who takes him into the kitchen and puts him in this fetal position? That didn't happen, ladies and gentlemen of the jury. And how do we know that? He fell in the kitchen.
I
because there was
know, but
one
with
witness,
his
and
accent,
he
it
had
doesn't
hit
come
his head
across
against the
that way.
counter. Because there was one witness, and that was the sister of
If
my
I was his
client.
partner, I'd tell him never to
Told
say
you
that
that
again.
she saw a dent, a fresh dent in the counter, in the kitchen counter. That's where he hit his head, and that's how he fell on the ground, on the kitchen floor. But not because some insulin injection, but because of some unknown condition that was caused or may have been caused by many, many, many different reasons.
21 is not bad.
Then,
21 is
continuing
bad.
with the cold-blooded killer's action, she
15 and 30, 40, depending on when you
does
ate.
not
Fine.
do anything but call all kinds of people to the house. Now, wait a minute. You have just decided to kill your husband. He is unconscious, let's assume, and you want him dead. Well, let him die then. Don't do anything.
Well,
Or maybe put a
witnesses.
pillow over his head and kill him. But do not tell me that you want to kill your husband and then you call 2 workers right there to bring Michael onto the couch. The sister and her husband, the state trooper and his wife, who is a medical assistant, and then Mr. Davis.
And they all said take
Is
him
that
to the hospital.
the action of a killer who wants to get away with murder?
Yeah.
No. No,
Enjoy, hubby.
no. And then, and again, I told you, that's the kicker. Then he dies, and she wants to hide all the evidence. She cremates him. And then all the
21.
evidence is gone. All these Dr. Kubitscheks and everybody else can look at all that evidence. No, they can't because he's cremated. That's how you, I guess, kill somebody the way the state believed it happened. But it didn't happen that way. And then the ultimate question, and the question is why? Throughout this case, the leitmotif, the state's main motif in this case was Michael didn't know anything about this business, didn't know anything about Natalie's shenanigans, financial, the fraud, the deception, the lies. He didn't know anything about it. Well, I think that from the very first day, ladies and gentlemen of the jury, you've realized that this is not the case. But let's assume for a moment that Michael is indeed blind and doesn't know anything about millions of dollars, hundreds and thousands of dollars. He doesn't realize where all that sudden wealth came from, doesn't know anything. And then he finally finds out. Let's assume that he finds out. And then the state tells you that he would do what? Well, the state cannot tell you. And the question is, what would he do? What would he do that would be so bad that would require Natalie Cochran to kill him? I mean, scenarios abound. You find out that your spouse is cheating the government, cheating the investors. What do you want to do?
Kill her?
You probably want to say, come on, let's get a lawyer. Let's get an accountant. Let's try to work it out. Let's call these investors. Let's try to pay the money back. Let's file for a bankruptcy. Let's maybe even talk to a friendly prosecutor in Raleigh County. Maybe you will have to do a little bit of time, but not run to the federal government and complain. What, was he going to kill her? Is there any evidence that she launched this preemptive strike against him because he was going to kill her, or that he was going to do something to her, divorce her? What would be her motive to kill him? Why?
People
She may
have
been
killed for
afraid that
less.
he would be mad, but to kill him, to eliminate him from what?
People
From
have
doing
done
what?
less,
From
dude.
going to the federal government? From complaining that my image is so tarnished now in the community that I want to divorce you and you will be penniless and all of that? There's no evidence of that, ladies and gentlemen of the jury. What triggered this murder? The state cannot answer that question. But if you had any doubts about Michael being involved in this scheme, and if you believe that he was, then the state's entire case collapses. Because she, Natalie Cochran, would have no reason to kill him. Because he, Michael Cochran, was as involved in this conspiracy as she was. And how do we know it? Well, he was working on these contracts daily, on these federal contracts daily. Even when he was hunting with his little son, he had a contract that he was working on. He was working on the contracts when they were in bed. And I'm not talking about anything sexual here. I'm talking about family. She's watching the TV. He is working on the contracts. Their little son with them, sitting between them, realizing that daddy's working on the federal contracts. He signs the checks.
Thank
from
you.
the company. He has access to everything, every bit
Huh?
of information that
I
goes
gotta get
through
drink.
this company, checks,
They're closed. It's after 3.
contracts. He has access to all of that. And besides, is he really living on a different planet from Natalie? Ladies and gentlemen of the jury, if I suspected my wife, we are, well, unless I'm in court, we're home. We're together. We spend time together. We communicate. Wouldn't I ask my wife, honey, where is all this money coming from? All of a sudden, I'm not working. I'm this computer tech guy. You're not working. All of a sudden, we're buying 2 boats. Well, the investors, yeah, but now we have 3 houses. Now, we just got back from Paris. Ladies and gentlemen of the jury, you've heard the evidence of incredible wealth, incredible injection, maybe that's a bad word, injection of wealth that Mr. and Mrs. Cochran had in 2018, 2019, maybe even 2017. And that came from the investors. And the investors dealt with Michael individually, just like his parents. They gave him some $44,000. He knew that there were no contracts. What contracts were they? What contracts were there? He didn't have a clue about some of the business, I'm sure. But he had deep, profound knowledge of how much people invested, who was gonna get paid for what, federal contracts. He had deep, profound knowledge of it. I'm sure there were some aspects of this business that he may not even know about. And I'm sure that Natalie was involved in this. But she is not here on trial for fraud. She's here on trial for murder. Well, let's look at the state's case. And mind you, the state has a very heavy burden, and the burden of proof beyond a reasonable doubt. Well, the state brought the evidence of the pilot who says, well, the flight was canceled. Okay. The banker turned mind reader. He had an idea why the flight was canceled, but of course he didn't. He is mad at Natalie because he had to do all that research for the company and didn't get paid for it, I'm sure. And for him, time is money. So they didn't fly to Lynchburg. Well, Natalie went to a doctor. She was sick. I think that the state attributes all these nefarious things to her, but isn't it just plain obvious from Dr. Halsey's testimony that she was sick? She was sick on Friday and she was sick on Saturday. And what did he give her? He gave her a steroid shot that increases blood sugar. So
Not that much.
she's calling her friend, Miss Davis, to get her some insulin to maybe level off the sugar, blood sugar. What's so unusual about it? No, it's nothing unusual about it because
Yes, it is highly
she,
unusual.
Natalie Cochran, had a long.
If you get a shot of steroids, prednisone is a standard steroid. It's what I've used. That's what I had to use for many years. I've gotten shots and, my blood sugar count, becoming a diabetic from a shot or lowering my blood sugar enough, or the prednisone or whatever the steroid is that you were given. If you had a risk of becoming diabetic that quickly from that dose, your doctor is going to have a conversation with you about that. Now you understand, I can give you a shot. It is so strong that you could potentially have a little bit of blood sugar control issues for a couple of days. If that's the case, I'm going to suggest if you know, test your blood sugar. If it's too low, well, then what you need to do is eat something sweet. So maybe get some glucose tablets, whatever. If it's too high above said number, they're going to give you a number. They're going to talk to you about it. If it's above said number, give me a call. We may have to give you a little insulin. So for me, I'm like, dude, this is so much BS. I'm going to actually ask some friends of mine who are currently in the medical field, and I'm going to ask them, how many of y'all have given prednisone to patients and then them turn around and become an instant diabetic?
Standing relationship
No.
with the Davises, who had a misfortune, a tragic misfortune of having a child who was diabetic.
And one diabetic medicine is
Davis
not
came here
the same as another.
and told you, no, Natalie never had any insulin. Oh, really? But then when we confronted her with the pharmacy records, she said, oh yeah, Natalie could pick up the insulin.
That was quick, hello,
But she was bringing it home. Well, what if you weren't home? Yeah, she doesn't explain it. Natalie could keep it at home. That was nothing unusual about Natalie having insulin.
Yeah,
And
that is highly unusual.
you know what? The state wants you to believe that this insulin, that bottle of insulin that was found, was the weapon, the murder weapon. That somehow it was punctured and she kept that bottle as some kind of sick souvenir of the murder. Is that what the state telling you? I submit to you, ladies and gentlemen of the jury, if you look all you need to look at is this Humalog.
How much
that we
insulin was
introduced in
removed
the
from that?
exhibit
Did they
as an
weigh it?
exhibit. I'll submit to you that a blind fool would tell you that this bottle is full. This bottle is full. There is nothing in this bottle that has been taken. There's no bubble, no nothing. The bottle is full. I suspect I know what happened, why there's a puncture. All these FBI gentlemen got that bottle and maybe had taken a little sample of what to determine what it is. That may be the puncture. But otherwise, the bottle is full. We're not going to sit here and speculate. They find a vial of insulin that is full 4 months after the demise of Michael Cochran. And then, that's part of their evidence. Remember Mr. Bledsoe telling you at the end when we finally pressed him, is there any evidence? Is there any evidence that the bottle that you have was the murder weapon? And the answer was no. And ladies and gentlemen of the jury, the lifelong condemnation of this woman versus complete exoneration is at stake. The stigma of conviction for murder versus letting her go free is teetering in the balance, and the state has the audacity to come here with an item that is not the evidence.
What?
And they're trying to
You're
tell
losing
you
me, dude.
to convict this woman of murder based on something that is not the evidence.
You're losing me.
Is that the case that the state has the audacity to bring before you? Well, let's look further. Chris Davis and at least one other witness, Mr. Treadway, and Penny Lowry knew that Michael Cochran was taking all those steroids, whatever, steroids maybe. Maybe they were steroids. Maybe they were not steroids. Maybe they were anabolics. We don't know. Michael was taking substances by the fistfuls.
You can't
And they
say
can
that.
say that, oh, we have isolated one little vial, and that was some hormonal thing from Mexico. No, ladies and gentlemen of the jury. He had a cabinet full of medications. He had a cabinet full of that away from the family, away from the cabinet or a place where the family stored the medication. He was getting this stuff online. He had the United States Postal Service box where he would get all that stuff. And I submit to you that this was not some one deal Mexico thing. And there's nothing wrong about Mexico. This was, however, the problem. He was getting substances that were not approved by the American government, by the
American
Food and
Medical
Drug
Association.
Administration. He was getting substances that were going to increase his physique, his appearance. But my God, they could have done some serious damage and probably did some serious damage.
There is your
One of
reasonable
them
doubt.
was not even for human consumption, as the children told you. That was
There
just a
is your
sample
reasonable doubt.
of what Michael Cochran was taking. And what he was not taking was the medication that was prescribed to him by the physicians. And yes, he had all kinds of conditions for which he had the medications. He had Keppra, he had all kinds of serious medications which he didn't take because he believed that all the doctors were quacks. He believed that they were not the people to be trusted.
He was self-medicating.
Chris Davis and Mr. Treadway and Penny Lowry tell him, you have to stop this stuff. You really cannot do this. And what does he tell Penny Lowry? She testifies. He said, oh, retarded Penny, what do you know? I'm gonna do whatever I want to. The state makes a big deal out of, Michael not being taken to the hospital. But you have witness after witness who told you that Michael not only believed that the doctors were quacks, but he hated going to the hospital.
Who
He
likes
vowed
going? Who likes going?
to kill somebody if he's ever awakened in a hospital. And why? Because he considered this a waste of time. Now, he had all kinds of problems that he went to the hospital with. And within the last 3 months of his life, he went to the hospital 3 times. October 31st. And then he stayed there for a day. I told him he had all kinds of problems.
All right,
Then he
now
went
you're
back
saying for
to the
someone who
hospital.
was going to kill someone for taking
Pretty
me
much
to
the
the hospital.
same conditions that
You're saying that he told people, if you take me to a hospital, I'm going to kill you. But yet, in fact, that you're standing there saying in a very short period of time, he was in the hospital 3 times. You just contradicted yourself there, in my humble opinion. And it ain't worth much.
he had now and stayed there for 5 days. And then he came out. You heard throughout this trial that Michael had convulsions, seizure-like activity. He probably had epilepsy. The doctors told you that. He had a brain mass that was later modified into the brain swelling, encephalopathy. Ladies and gentlemen of the jury, those are serious conditions. They are not to be laughed at. Those are very serious conditions. He retained urine. He had an enlarged heart. He had an acute respiratory failure. He couldn't even breathe because he had a chronic sinusitis. nobody is here to desecrate or dishonor his life. He died much too prematurely. He died at the age of 38 years. Not for a moment should you think that the defense is taking his death lightly. No. It's a horrible tragedy, but a tragedy, not a murder. It's a tragedy, ladies and gentlemen of the jury. But with all these conditions,
I think we're going to have a hung jury
Michael
or lesser.
was still doing what Michael was doing, taking supplements.
He's doing a very good job.
anabolics, substances that God only knows where they came from and who approved them. And he was a ticking bomb. And how do we know that? Well, after his second stay in a hospital, at least 3 witnesses told us that Michael's health has deteriorated to the point where Michael was not the same guy. When he was Michael at his best, he was generous, gregarious, going to parties, participating in tough man competitions, lived life to the fullest. He was focused. After his second stay in a hospital, Michael could not find his car in a parking lot. Forget that. That happens to me quite frequently. But that was just one symptom. He could not fix a light fixture with Mr. Davis. He felt confused. The children testified he had constant headaches. He was irritable. He didn't know where he was. Mr. Treadway came here and testified, Michael hated going to Panera Bread with a passion. He hated the restaurant completely. And I know that this is not a case about Panera Bread.
I've never been to
But if I
Panera
hate
Bread.
a restaurant, I'm not going to set foot there. And yet Michael went there and could not even recognize the fact that Mr. Treadway was wearing the same hat that he's been wearing for years. He was confused. There was something going on in his head that made him
Sugar
go
levels,
where he would
baby.
never go, and that made him forget who his friend was, really.
Sugar levels will do
Now-
that. Causes confusion.
The state brought before you
We don't have a Panera Bread
those
here.
2 FBI agents
Maybe I ought to go to San Antonio just to try it out.
who, again, could not contribute anything scientific except for that bottle. And the state closed the case with 2 law enforcement officers who are here today. Have you ever seen a more shoddy investigation that took place in this case?
Oh, that was a punch to their gut.
They never
They're
talked
here
to the
today. They
children.
did a crappy job.
And I know that the state will say, oh, this was not that important. It was important. The children's testimony was riveting in this case. And I'll come back.
I need to
that
go
in a
back
second.
and hear that.
They did not even check what kind of medication this man was using. And for that matter, they have no clue about Natalie Cochran's medication. And, they tried to convict her in part because she lied about her cancer. Oh, that's a low blow.
Low
First of
blow?
all,
Low
we
blow?
have absolutely no evidence that she did not.
Lying about cancer is a freaking low blow. I'm yelling. I'm trying not to yell. Lying about cancer is a freaking low blow. You would have been better off not even bringing that up. Because if I was on the jury and I heard that again and you brought that to my mind, I'm going to be pissed. Way pissed.
Not have cancer. We have the evidence that she was going to seek help from the Cleveland Clinic, from Duke, from the doctors, wherever she could. And knowing our medical system in this country, it's not that you're going to walk into the Cleveland Clinic and you get treatment the same day. You have to have insurance. You have to have all kinds of, you have to go through all kinds of
She
hoops to be
walked
seen by a
in-
specialist.
She
And maybe-
walked in.
When she told somebody, yeah, I have cancer, leave me alone, because she maybe didn't want to discuss her health with somebody.
When you walk into a clinic or a doctor's office and say, I believe I have cancer, then they're going to run a ton of tests on you. And then they're going to send copies of all that to your primary care physician, which they did not. She wants to sit there and say, oh, I have cancer. I'm going to the doctor. I'm getting checked out. You don't know if you have cancer until after you go through the test. So why are you sitting there saying, I have cancer? Something's wrong. It could be cancer. This whole thing about the cancer, he should have just left it alone.
Maybe in reality, she was checking out whether she had cancer and went to all kinds of doctors and clinics to obtain that health. And the state believes, oh, she lied because she told you that she had cancer. The officers ignored the federal investigation completely. And in the federal investigation, in the indictment, in the forfeiture proceedings, in the federal case, it's the Cochrans who were responsible for the Ponzi scheme. But the indictment didn't come until September of 2019, and Michael was dead. I submit to you that the federal government was investigating them both.
But she owned the majority.
You can come here and say, well, I saw some cases where the couples were not investigated together. That's baloney. The federal government investigated them both.
Yeah,
and
they
would
did.
have indicted Michael as quickly as they indicted Natalie for the same offenses, because Michael was involved in this Ponzi scheme up to his eyeballs.
Matt, go. Go, Sensei.
Now, let's see what evidence the defendant presented. Remember Nurse Holly, if I pronounce it correctly, Holly, yes, who said that she was at hospice. And what did she observe? Natalie Cochran was with her husband for the last 5 days and held his hand when he passed away. There's evidence that Natalie Cochran got into a car with Mr. Davis. Well, the state said, oh no, she didn't drive him to the hospital. Well, she didn't drive him, but she was a passenger in that vehicle driven by Mr. Davis. She didn't drive him because she was too distraught over his condition, but she still got into the car and held his hand. Is that the cold-blooded killer?
Yeah, that can be. That people have, was it
She also
Munchausen
testified
by proxy?
that
Unaliving their,
Natalie Cochran was a go-to woman, and I think that she may have used that phrase, or maybe I have used that phrase, when it came to the emergency situations involving Mr. and Mrs. Davis's child. So Natalie Cochran would have to have insulin. You don't treat insulin with a water pill, for God's sake. You have to have insulin to treat it. And if she was a go-to woman, she must have had insulin to treat the Davis's child. So there should be no surprise again that she had insulin in her possession. Mr. Treadway didn't want to talk to the police because he believed they were dishonest crooks. And he somehow, by the way, he got scammed financially. So he had absolutely no reason to be friendly to Natalie Cochran. and testify on her behalf. Similarly to all these other witnesses, even her sister got scammed to the tune of about 50 grand. And yet she came and testified for her sister.
200.
What did Trade tell you?
Grams?
Well, Michael was confused. Michael wasn't the same guy
Holy crap, that's a lot of money.
that he had been before. And then Penny Lowry, the retarded Penny, as Michael called her. She told you not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back. Michael was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then I told you that the children testified in a riveting way. And you're going to tell us, well, the state probably will tell you they're coached or they were somehow not truthful.
Dude, you don't bring up that
Two
stuff unless
tragic
it's already
figures.
been brought up. You are hurting your
Tragic
case.
figures. 2 children who were young enough to be taken care of by father and mother and old enough to know what was going on around their house. Nikki testified here unequivocally that her father had headaches, he was confused, had a brain fog, was agitated. In a true, genuine, heartfelt way, she told you that he may not have been as loving towards her as he was towards their son. Michael had a heart-to-heart with her shortly before he died. And her impression was that her father felt it coming. And what was it? It was death, ladies and gentlemen of the jury. Michael felt it coming. And he had this heart-to-heart conversation with her, which she considered heartrending, and which we would consider his farewell to life, because he knew that there was something irreversibly wrong with him. The MAC, their son, testified too. Dad worked on the contracts all the time, even when hunting, even in bed. And he testified about their lifestyle. He testified about the supplements, the injections, the dropper, the stuff from Mexico, as he called it. Stuff that wasn't for human consumption. He remembered it all. He testified about his father's anger, his father's combativeness, his father's confusion.
That's the meds.
I want to talk to you very briefly.
You've
about-
gone over an hour. You got a minute.
Before I do that, there was also a brief mention of nootropics, a medicine that came from some shady, well, maybe not shady, I shouldn't say that, places that usually would not be available in your local friendly pharmacy. That was the smart drugs that Michael was receiving at his USPS, United States Postal Service box. These were the cognitive enhancers, memory enhancers, stimulants. Michael was perhaps a man's man, and he would not admit to any weakness. He was seeking desperately to look great, to be this, I don't know, alpha male, whatever you call it, to be this great, maybe bodybuilder, maybe an athlete. And yet in all of this, he didn't follow the advice of those who should have given him the advice and who he should have listened to, and instead did his on his own. Now, I want to return for a second to the experts who testified in this case.
Has it been an hour yet?
Let's start with Dr. Kubitschek. All of these experts, by the way, had a number of autopsies that performed. But who was in the best position to tell you about the autopsies? Who was in the best position? Well, of course, it was Dr. Kubitschek. He performed the autopsy the earliest. And with all the help of the state resources, and relatively early in the game, when the body was not perhaps yet decomposed to the point that nobody could recognize the organs anymore, he told you that the cause and manner of death was undetermined. Then there was Dr. Howley, who was not necessarily an expert, but he told you a couple of nice things. One is about, of course, about Natalie being sick, but he also said something about tablets, the pills, and the state jumped on it. And now the state submitted another theory that maybe Michael was killed by Natalie with pills. For that matter, the state is bringing another theory now that maybe she killed him with the benzos. You heard about the benzos. Now the state says maybe there were 2 shots of insulin or maybe more. Now the state tells you she killed him in the kitchen. No, she killed him in the bedroom. Now she killed him
Here
with
and
the
there and
prednisone,
everywhere.
maybe. And then
Jeez.
maybe any other substance. And the state will stand up at the
Thanks
end
for
and tell you
informing
that
me.
whatever I tell you is a bunch of nonsense. But, ladies and gentlemen, you've listened to the evidence. If the state stuck to its theory that there was 1 insulin shot, I could buy it. But now the state quietly is telling you, well, we're not telling you that the evidence suggests that the defendant killed her husband with insulin. There may have been pills, there may have been benzos. They're intimating this because they don't have any direct evidence, to which they immediately admitted, but they don't have any circumstantial evidence that fits either. Now, you had Dr. Dragovich, who told you maybe one very important thing, and that is that the decomposition of the body caused the inability of any doctor, for that matter, to assess objective factors, objective anatomical factors, and the findings of any type of specific, concrete reasons for Michael's death. That is impossible. Dr. Uribe believed that there was an insulin shot, but this was just an assumption. It was kind of a bridge to the unknown.
Don't know what happened there.
That led to the death of Michael.
As Michael called her. She told you not only about that fresh dent in the kitchen counter, but Michael wanted to pay her back what she owed on the contract. Michael wanted to pay her back.
I don't know what happened there, y'all.
Michael
Sorry.
was dealing and wheeling with the money from the investors. He knew about it. She told you, again, the same story, that Michael refused to go to the hospital because he was going to kill somebody if he went went back to the hospital and woke up there. And we have all these discussions between 5 or 6 people after Michael collapsed in the kitchen. And then that we really don't know. But there are other possibilities. There was something wrong with Michael's pancreas. Remember that? He may have had pancreatic tumor. He obviously had an enlarged heart. Arrhythmia. Maybe there was something wrong. Maybe that was the reason. The tests were not done on any C-peptide insulin. No meaningful diagnosis from the sliders that were obtained or that weren't obtained. Could have OD'd on benzos. We don't know. Benzo overdose, maybe poisoning. Hypoglycemia equals death. Well, all of that. And then, of course, there are other reasons. The medication, alcohol, unexplained medications, liver disease, sepsis, surgeries, immune system. All of this could be taken into account in Michael's death, but the state stubbornly believes that Michael's death was caused by that one insulin shot, which they, by the way, changed and modified to maybe 2 or 3 on all these versions. It's impossible. Impossible, ladies and gentlemen of the jury. Now, the state also brings a theory of maybe there's this voluntary manslaughter, that just because she didn't take him to the hospital. Well, I submit to you that not taking Michael to the hospital was not done over the period of days. It was a matter of hours. It was a matter of discussing Michael's preferences and will, whether he was going to go to the hospital, whether he wanted to go to the hospital, and what was necessary. We had several people in that house who could have decided. Finally, it was decided that Michael was going to the hospital because he was not waking up. Yes, it took some time, but there was always the hope that he would wake up in his own home, surrounded by family and friends, and everything would be fine. After several hours, yes, it became necessary to take him to the hospital. But that's all. Now, ladies and gentlemen of the jury, I told you at the very beginning of this case that this is a complex case. That this is a case that involves medical, banking, scientific, maybe pharmaceutical, maybe business, evidence and information. There are aspects of federal litigation here. And you've heard it all. But distilled to its essence, this case really involves the state's attempt to equate the federal prosecution and conviction for dishonesty and fraud with murder. The state says she is a fraud, therefore she is a murderer. She is a cold-blooded murderer because she is a cheat. That's what the state is telling you. But the state cannot prove, certainly not beyond any reasonable doubt, the what caused Michael's death, the how did that happen, and why it happened. And so at the end of this case, I will tell you that the state's attempt to equate the fraud with murder is like trying to squeeze a square peg into a round hole. And if that one peg didn't fit, then the state switched the theory, and let's see if another peg that is still square will fit into that hole. Oh no, it won't. Well, then we'll switch to another theory. Maybe benzos, maybe two shots of insulin, and it still doesn't fit. Ladies and gentlemen of the jury, the state will have the last word. In the criminal process, I will sit down and I will not address you again. My esteemed colleagues and friends will get up and tell you that whatever I told you is nonsense. They will give you the spin on the facts and tell you that's the way it is. But I heard a
It
statement.
very well may
once
be
that-
that's the way it is.
And of course, when you go to the jury room, since they spoke last, you will have their words in your mind, in your memory more than mine, than my words. But I heard a statement once that it's not the one who speaks last, or trust, not the one who speaks last, but who speaks the truth. We have no reason to come here and hide anything from you, ladies and gentlemen of the jury. Ms. Cochran should not be perhaps invited home for you to have dinner with her on Sunday. I told you that. She is committed crimes of fraud, crimes of mail fraud, crimes of dishonesty, but that doesn't make her a murderer. And if you cannot answer these three questions, what, how, and first of all and foremost, why, then the
Who?
state
Not why.
fails to prove its case beyond a reasonable doubt.
They don't have to have a
And
why.
that's why we're asking you to find
Motive is not always there.
Reply, Ms. Akron.
No, it's back to me.
I'm going to put this
You are
back
so
to
close to
normal.
listening to all the stuff. Be silent on this side, and then you will take over. On behalf of the prosecutor.
Now, I'm going to say this. I disagree with the closing on this attorney. It's the what, when, where, but the why is not always known. That's motive. They don't have to have a motive to find someone guilty.
Prosecutors. Excuse me.
Y'all hurry up and answer
On
our
behalf of the
poll
prosecuting attorney's
before I
office,
shut it.
The investigators, we thank you for your time, your effort, your attention, your sacrifice. Without you, this system cannot work. Can I touch your equipment? I should have asked.
Thanks for not asking.
Do you need to hit this?
The sheriff is like, come on, dude. Let me zoom.
Talk about something else here for a minute.
What are y'all thinking? Y'all are very quiet. Are we listening
I'd like to
intently?
talk with you about two numbers. And the first one is this one.
0.
0. The defense is right. We're going to tell you that what you just heard is a lot of nonsense. And the reason why it's nonsense is the defense has no credible evidence to back up any of their theories as to why the state is wrong. Let's start out with Michael Cochran himself. They have a very schizophrenic approach to Michael Cochran. One theory of the defense is he was this macho, bodybuilding, fit guy, athlete, Jeep pulling, super stud guy. That's one theory. Now they have some evidence that he was very concerned about his fitness, very concerned about his appearance. We would agree with that. But did that lead to his death? Zero evidence to support that. On the other side, oh my gosh, the guy was a ticking time bomb. The defense words, a ticking time bomb. He was so sickly. He was essentially a guy with 1 foot in the grave and 1 foot on a banana peel. They don't really have any evidence of that either. He was just a normal 38-year-old healthy male and a good guy by all accounts. So the hospitalizations that they've relied upon to tell you how sickly this man was, where did most of the information come from that? Medical records. Who provided histories for that? The defendant. The defendant told the doctors all of these things about Michael Cochran. It didn't come from other reliable sources. It came from a very unreliable source, her. So his suspected brain mass, his suspected convulsions, his suspected all of these problems, there was no diagnosis of any of those things. They were suspected. And they were suspected because she told them to suspect that stuff. But there was never a diagnosis. Even their own experts confirmed that. There are other witnesses. The fact that the Davises talked to a nurse to have Natalie Cochran, their emergency contact, that's not the same thing as authorizing treatment by Natalie Cochran of any child. There's zero evidence of that. There is evidence on the other side. The Davises told you they never gave the defendant insulin for the benefit of their child. Never. Both Davises told you that. As recently as yesterday, the defense was still putting that theory out there for you to consider. There's no evidence to support that. Zero. Mr. Treadway's testimony was Mr. Treadway's testimony. This is a guy that didn't want to help the police. Even though his best friend was dead, he wouldn't talk to him. And he had some newspaper article he said gave him justification for that. That's on him. Treadway's got to live with that. But he didn't bring anything of substance to this case, did he? No. The two children that testified, they are tragic figures. They have had a terrible 6 years. They lost their dad. For the time being, they've lost their mom. But they were little kids. And their testimony had a certain ring to it. They both picked up on the same word, agitated. That's an unusual word. Rolling back time 6 years, think that the oldest was 20. She was 14 at the time. And that's how she's going to describe her dad the last few weeks of his life, the word agitated. Her brother, the same word, and he was younger than her. There's something odd about that. The state believes that they sincerely believe their recollection. But does it make sense? Would kids that age really be that involved in their parents' business? Would they? Well, it's possible, but that's not very likely. The defense experts, nice people, very sincere, but they're in a little silo. If those forensic pathologists can't cut on a dead body and come up with a smoking gun reason, then their opinion was they won't give you a cause of death or a manner of death, even though Dr. Banerjee said, oh no, we don't do this in darkness. We look at all the facts. We look at all the circumstances. And the autopsy is just a part of the process of determining these things. But was it? Did she have any facts that were right at all? She had a few, but not many. And in her own report, she said, if other information is brought to my attention, I reserve the right to change my opinion. Well, she had a bunch of other information, but she still wouldn't change her opinion. Why not? That's just her mindset. Did she have any experience in insulin cases? This was her first case, her first one. Dr. Drakovich, apparently he didn't have any insulin experience either. Now, the defense told you that the state has just gone all over the lot with its theories. Is that your recollection of the evidence? Did you hear any state witnesses say there was one injection of insulin? No. Did you say multiple? Because we don't know. But there are some things that we do know. Now let's talk a little bit about how that balances out what the defense just told you. There's a lot of circumstances that need your consideration. First of all, this is a trained pharmacist. a pharmacist who knows about all sorts of medication, the impact of the medication, the dosage of medication. Beyond that, this defendant held herself out as a diabetes specialist. A diabetes specialist. That's another circumstantial piece of evidence to keep in your mind.
Mm-hmm.
On February 6th of 2019, on the basis of a supposed counterbalance to her cancer treatment, she needs to borrow a bottle of insulin.
You don't borrow it. You
Another
need to have it.
circumstance that needs to be held in the
Borrow
back
gives
of your
back.
mind. Because on that day, they were supposed to fly to the Bank of America. And yes, there is a merger with the federal case and this case, and that's where the merger takes place. You heard Trooper Heinzman discuss all of the things that the defendant had told her investors about the money that was supposed to be coming in, the money that was going to be coming in, the money that was almost going to come in, and it never did. Who else did she tell that to? Michael Cochran. So when the defense says, oh, he was up to his eyeballs in this, was he? Does the evidence support that? They have zero evidence to support that theory. Zero evidence. He did live a lavish lifestyle. But if he thought that the money was there for good cause and that the business was just supporting that lifestyle, was there anything wrong with that? Of course not. But this was a person who ran a Ponzi scheme. And the one thing you can count on for people that run Ponzi schemes is they will do whatever they can to keep it going. Is that what she did? That's exactly what she did. She was still shucking and jiving after Michael Cochran died. Right up until they executed the search warrant, she was doing ordinary business, selling the non-existent contracts, trying to get people to invest. So there is zero evidence that Michael Cochran was up to his eyeballs in this, but this defendant was up to her eyeballs and over her head in this fraud scheme by their own admission. Second number. $21. That's a big number. And that's the number we're going to rely on to convince you beyond a reasonable doubt that this defendant killed Michael Cochran. That number was the number of his blood glucose level at Raleigh General Hospital at 8:30, the day of his collapse. Now, unlike the defense witnesses, the state witnesses were unified and very clear as to what caused that 21 number. Dr. Krieger had 13 likely causes of low blood sugar, hypoglycemia. She eliminated all but insulin. And she's got a good reason for all of them. You heard her testimony. All of those were potentially valid causes of the condition that led to the brain swelling, that led to the death of Michael Cochran, all of them. But she eliminated by logic and by her scientific skills and experience in insulin cases that it had to come from insulin. Dr. Uribe, another experienced insulin investigator. Both of those two were involved in the Clarksburg VA murder cases where a nurse was killing veterans with insulin. Those two were the government's star witnesses. They know what they're talking about when it comes to insulin. And it comes to insulin killing people. That's what they do. So that 21 was never overcome by a single shred of credible evidence by the defense. Not once.
They don't have to. You have to
No
prove
one's
beyond a
told you
reasonable
from the
doubt,
state
not them.
that there were single injections, multiple injections. We don't know the answer to that. We do know that Michael Cochran's death was caused by insulin and reducing his blood sugar to a fatal level, and the resulting
Hello,
changes in
Penny.
his
Thank
brain
you so much,
killed him.
love. You're entered.
Circumstantial evidence is the basis of this case, and let's get this a nice, straightforward example of what that is. It's January in Raleigh County. You look outside your window and you see frost on your neighbor's truck, frost on the ground. Stars are out, moon may be out. You go to bed. You wake up the next morning and there's 8 inches of snow on top of the truck and on top of your grass. Did you see it snow? No. Did it snow? You absolutely know it did. That's circumstantial evidence. Ladies and gentlemen, the state of West Virginia has dumped a blizzard of circumstantial evidence on this
Good
defendant.
use of
Until
words,
today,
dude.
2 weeks in an American courtroom. And until today, you never heard the word justice. Well, do justice for Michael Cochran. Find this defendant guilty of first-degree murder, because that's exactly what she did. Thank you.
Ooh, that chair's squeaky.
Members of the jury, you have now reached the final stage of the trial. This is the point where I would ordinarily release the alternate jurors and send the regular jurors to the jury room to deliberate upon your verdict. I see that the time is almost 15 till 5. Ordinarily, I would close out the day at this time, as you know, and send you home for a nice dinner and watching TV and then going to bed. However, you folks are in the
Not
catbird
tonight.
seats. You are the judges of the facts, and you can tell me at this juncture what you want to do. And if you would like to retire now to deliberate upon the verdict, that would be fine. We will stay here and we will wait until you reach a verdict. However, if you would like to start afresh tomorrow so that you've gotten a good night's sleep and you can think a little more clearly, you can come back at 9 o'clock at the regular time and commence your deliberations then. We have talked among the attorneys about engaging in a powwow among themselves, and I would urge you to engage in a powwow among yourselves and see if you
Don't
can
use the word
reach
powwow.
some unanimity on what to do. Again, you can stay this evening and deliberate, or you can come back tomorrow. Perhaps you can confer for a moment or so and decide what you all would like to do. I'm hearing tomorrow. All right. That's the decision I would make. But again, I'm not you guys. I'm not going to release the 2 alternate jurors. I'll ask you folks to come back with us because I've been at this game a long time, and I know that anything can happen with jurors in terms of sickness and accidents and that sort of thing. We've done really well, and you folks have been great. You've been here promptly. You have watched and considered everything. I've been sneaking looks at you, and I noticed that you have done very well in terms of paying attention to the evidence and the proceedings. So I will ask all of you to come back tomorrow. Even though we have reached the deliberation phase, you still can't talk about the case because you haven't started your deliberations. And I'll tell you in the morning that you all need to be together You all need to discuss the case together and not break up out into factions or have folks wander off. You need to talk about this together and share your concerns and share the issues that you have arrived at. So that will be to start tomorrow. I'll tell you about selecting a jury four-person in the morning, and we will get down to business. So if you could all be back in your jury room at a little bit before 9. Do not discuss the case among yourselves. You're not at the deliberation phase yet. Do not talk about it to anyone else. Don't watch TV about it. Don't do any research online or see anything online. And please don't read anything in the newspaper about this case. Have a good evening, and I'll see you folks at 9 o'clock in the morning. You may follow the bailiff. All right, are there any matters we need to discuss at this time out of the presence of the jury?
Nothing from the defense, Your Honor. Thank you.
All right, thank you very much. I appreciate your cooperation in this trial. We will return at 9 a.m. in the morning and see what develops. Court is adjourned.
Oh, that's nice. Look at them shaking hands. He's going over there to shake her hand. Everybody's being cordial. I tell you, this is an interesting case. I wished we would have followed it more, but we can't follow every one of them. Your poll, I'm going to close it, is 67% guilty, 33 not guilty, 9 votes. So that would be a hung jury if we had to use that as a jury. Okay, you guys, if you've not liked this video yet, you better go in, because I know I've got at least 16 likes and I only have 9 entries into the I liked. So go and click that like button. Come back and type what's in that little bubble there in the comments before I draw today's winner. I'm going to take that off. I'm going to get ready to close this down. So it's, almost end of day here. So what we're going to do is we are going to end for today after I do the drawing. And then when we come back tomorrow, we will be waiting for jury verdict on this case. And then we'll have the other case going live as long as it is live. It depends on if that lady is injured, and if so, how injured is she? So we'll just have to wait and see what happens with that case tomorrow. So, okay, I'm going to do the drawing. We're going to do the drawing. Okay, here we go. I thought it was Bama Green Eyes. Oh, Haley Mouse. You did it, Haley Mouse. Woohoo. I got to get to the right page. There it is. Congratulations, Miss Haley Mouse. You're in my book. Yay, Miss Haley Mouse. Okay, guys, y'all have been fabulous. It's been a kind of an interesting day. Been kind of a down day for me. Quiet, nothing major going on, thank God. I am going to take a little break. I've got a ton of homework to do. I will we will get into the care and read documents tomorrow. Cancel, get that down. So we will definitely get in all that tomorrow. Please share these lives with people. It really helps me when you share them. And it helps when you hit that thumbs up button. That really means the world to me. Tomorrow will be Wednesday, the 29th, and we will be back in this trial and the other one, the Monica Cinematelli trial, where she is accused of unaliving her husband via hiring her boyfriend slash adult filmmaking star. It's crazy. You want drama, that's the case. So we'll be doing that tomorrow. In the meantime, y'all stay warm. Smile and love on somebody who needs it today. Remember, it could be you. Everybody has a hard day, so try to be nice to somebody while you're out and about, even though you're busy. Try to share some love. And we will be back here tomorrow. Okay? Blessings. Have a great evening. See you at 8 o'clock in the morning. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.